Good morning, everybody. Welcome back. Welcome back. A little earlier on our Tuesday, back on that bright and early rise and shine. The days are getting longer, so it's not even that bad anymore. Like it's already light outside. I got water the trees. You have that morning light when it's kind of just starting to glow, make the tips of everything get a little bright. It's actually not so bad. But after 3 full days of Yuri Buchanan, I know I'm not the only one that's wondering, where do we go after that? How is the Commonwealth gonna follow that up? I don't think they were expecting that marathon cross. And so where do we go from here? It does seem like the options at this point are fairly limited unless we have a whole shift in strategy, which, hey, we got a brand new motion yesterday to take a sharp left turn into collateral issues and bring in the Aruba sisters. So could be up in the air. I've seen some folks suspect that we could be getting the niece and nephew very soon. I know we got an order. Judge Cannoni signed an order essentially governing the use of the cameras when and if the child witnesses testify. Last trial, they were not recorded. They were not televised. Same rules this time. So that could have been in anticipation of the witnesses being called soon. So that is possible. We also continue to await the tech people, the Commonwealth's tech people. Last year we had a number of them. I don't know if we're going to get all of them this time, but at a bare minimum, I think we need Maureen Hartnett. She was the one who went to the Canton Sallyport, took the big news. We just got an email from the court system that says court is canceled today in Karen's retrial for unavoidable circumstances. We'll try to learn what those circumstances are. That is Ted Daniels over here on X. Usually a pretty good, reliable source. Well, that would be not what we're expecting. That would definitely be different. Don't know why. Maybe we'll find out. Huh. So probably no child witnesses today then, if that's the case. No lab people. Well, we'll hang out and see if we get more information before we go ahead and conclude that's it for the day. Do hope we get a little bit more detail about what's going on. Well, we'll just wait and see. In the meantime, what else is going on, guys? There is, I did see one thing I'll share with you. There's been more movement on the First Circuit order because we saw the order last week that came down. Big win for Mark Randazza, big win for the folks wanting to protest in the buffer zone. The First Circuit saying the order needs to be narrowly tailored so that silent, not disruptive conduct that doesn't, pose the risk of interfering with the trial process can take place in the public square. Let me see if I can pull that up. Here we go. So that order came down, and yet nothing has happened at this point in time. So this emergency motion to clarify and enforce the judgment from May 9th. It's now 4 days after that judgment came down. So Friday, and as of Tuesday, the order has not been modified. So specifically, Mr. Randazza is asking the First Circuit, hey, the lower courts aren't dealing with it. The order remains in effect. It is continuing to interfere with people's valid exercise of their First Amendment rights. So somebody needs to fix it. Why don't you go ahead and do it? And so he's basically arguing the district court hasn't gone back and, evaluated it. Instead, it's letting the case, quote unquote, languish for a week so that Judge Cannoni, the state court judge, might act if she chooses to. District court stayed the case until May 19th. And, that's another 6 days down the road. If the order is a violation, that's a continuing violation every day that it remains in effect. So Mr. Randazza is taking issue with that. He's saying it needs to be addressed. Urgency is required. Every day the buffer zone order continues unrevised is a day the First Amendment can never recover. One of the things I found interesting about this is he supports it with a declaration from somebody who has been present there in the buffer zone. And essentially, he's just, they're taking issue with the delay. The order says what the order says. There's no reason why it should take, 10 days from the day that they make that decision for the order to be modified. But in the meantime, here's what is still going on in the buffer zone. They have this declarant, Erica Walsh. She went into the buffer zone on Friday. She was wearing a sweatshirt that reads "Criminals Control Norfolk County" with the logo microdots. This sweatshirt, "Criminals Control Norfolk County." Seems pretty classic First Amendment behavior to get to criticize your government officials, express your opinion about how they're conducting themselves, doing their job, etc. Pretty classic First Amendment activity. Nothing here makes it super obvious that this is going to interfere with Karen's right to a trial, Karen's right to a fair trial. So as she was leaving to go to her vehicle, she was detained. "You're not going anywhere," told she's going to catch a charge for wearing the sweatshirt. So she has to take off the sweatshirt. And what's she wearing underneath? She's wearing a Free Turtle Boy shirt. Journalism is not a crime. Free Turtle Boy. And the officers aren't clear if that shirt is allowed either in the buffer zone. And so to ensure that she doesn't get arrested, what does she do? She has to walk back to the car in her bra. That's the effect the buffer zone was having. Now, does some of this look a bit to me like it is they're deliberately acting in accord with what the First Amendment, the First Circuit said was allowed, but the buffer zone order as it currently exists says is not? Yeah, I could see that. Why? Because she goes back on Monday wearing the same sweatshirt. So is this trying to be quote unquote provocative? Yeah, probably. But that's kind of the point. It's kind of the point. If the First Circuit has said this is allowed and the order on the buffer zone says it's not, well, then you should be able to wear your sweatshirt. And you don't have to leave your sweatshirt that you like at home because the cops say you do, because the cops say you're going to catch a charge or whatever. If the First Circuit has said that's the type of thing that is allowed within the buffer zone. So just an interesting set of affairs that still remains. Is the First Circuit going to intervene in this? I really don't know. I really don't. 10 days to modify an order is not really that long in court terms, in, court years, court days, whatever. Not really that long. But we are talking about We are talking about a First Amendment. We're talking about a continuing violation, a continuing situation that isn't being addressed. So it is possible. It is possible that it might. Just happened to see that come up, and because the First Amendment issues, I think, are very interesting. It's a very interesting implication of this case. So I wanted to kind of follow that and see what's going on with that. Why not just have her turn it inside out? Good question. Good question. Seems like a not unreasonable approach that could have been taken. It wasn't clear to me from how the declaration was written that she was actually ordered to remove any of this, or if this was simply a choice that she made to avoid trouble. You know, you don't know what the police are going to do, so you self-censor, you act in ways to try to avoid harm, even if it's within your rights to do that. That's the chilling effect of problematic stuff that violates the First Amendment. And I mean, what do you do if you think you're going to be arrested, or you could be arrested? What do you do? Do you err on the side of, well, you know, what the hell? Roll the dice, see if the police are gonna put up or shut up, or do you just go ahead and, in an abundance of caution, go ahead and take off that sweatshirt just to be sure, take off that t-shirt just to be sure. So I see some folks in the chat would like to go back and take another look at this video from yesterday. We got new video, guys. It's been a long time since we've had any brand new evidence in this case. But we did get some yesterday, because this video of Brian Higgins in the parking lot, we have not seen this before. So it was it's quite exciting to get that. Let's go ahead. I've got it here from the last trial. We can just go ahead and take a look at that. Let me see if it doesn't want to let me full screen it, but we can see it. So we'll just let's go ahead and take another look at that video.
I don't know which side this is, so I can't argue with you about the location. So I'll agree with you that we can call it that.
Great. It looks like a parking lot. This car.
Yes, sir.
Okay. So just
definitely does look like a parking lot.
We'll call this rear lot main side. That doesn't mean anything unless you adopt it. So just for identification purposes.
Thank you.
If we could move to runtime 1:26:32.
What cars there for supposedly Higgins needing to go move cars?
It's course mission played at this point.
Okay.
Thank you. Stop.
There's that Jeep that showed up with no plow.
Yes, sir.
I didn't see the plow at
car
first.
That looked like to you?
It looks like a two-door Jeep Wrangler with a plow on it.
Okay.
It did have a plow? I didn't see a plow. Oh, yeah, it does. Okay.
Okay, stop. Sergeant, did you, during the course of your investigation, learn whether or not anybody associated with your investigation had a two-door Jeep Wrangler with a plow on?
Yes.
Who's that?
Mr. Brian Higgins.
Okay, thank you. Let's go ahead and play this.
Learned that Brian Higgins has a plow. We already knew that. His Jeep Wrangler with the plow. Remember, Higgins went back to the Canton Police Department so he could move the vehicles. that he had parked there so that the parking lot could be plowed. That was his explanation.
Okay, stop. Sir, do you see a person who appears to have alighted from the car?
He stood there and listened to his phone?
Sergeant, if you could turn your attention to the screen on the right. Does that appear to be the location?
I'm going to pause this real quick for those of you joining. I'm going to put this banner up. Yes. Court has apparently been canceled today. We learned from Ted Daniels. So we are just waiting to see if they get more information so we can figure out what's next. In the meantime, we are revisiting this new evidence from yesterday, this video from the Canton Police Department parking lot. Seems to impeach Brian Higgins and his prior testimony about what he was doing there, how long he spent there, et cetera, et cetera. So it's new. It's been a long time since we've had some brand new information in the case. So we're just taking the opportunity to revisit it and see if there is anything that we can learn from it.
Of the person that you're describing?
That's the individual that came out of the vehicle, yes.
Okay. I know it's super blurry. You may not be able to at this point. Do you know who that is?
I do not know.
Okay. Let's go ahead and play it. Okay, stop. All right. Did you see the person walk off the screen?
Yes.
Did it appear that that person had something in his or her hands?
Possibly, yes.
Okay. May I have a moment, Your Honor?
Okay.
Thank you, Your Honor. If we could play the second clip on this same GG. Before this is played, Sergeant, do you recognize what's depicted in this photograph?
I do not know.
Okay. Let's go ahead and play this.
Yet another plow.
Stop. What do you see on the video at this point?
An individual crossing the frame with a couple of cars parked, one of which has a plow on it.
Does it look like an exterior video?
Yes.
Does that appear to be an exterior video if you don't know exactly where, an exterior video of Canton PD?
From the facilities, yes.
Okay. And describe the person that you see in the foreground at the bottom of the screen.
Terrible posture. Terrible posture.
Appears to be wearing a black sweatshirt, a hooded
I stand
sweatshirt.
by the
Larger
terrible
in stature, smaller in
posture.
stature, can you tell?
I'd be speculating because there's no comparison, but possibly larger. I don't know.
Okay, let's go and play it.
A bit rotund. Head
And that's it for
forward.
that. Your Honor, if we could play the next video. By the way, can we agree before we move off of this, just for identification purposes, can we agree to call this rear lot cruiser side as opposed to rear lot main side, just to keep them separate?
Same as last time. I'm not aware familiar where that camera is, so I cannot argue with you nor adopt. But if for identification purposes only, we can agree on that.
Can you see from where you are, and I know the answer to this, can you see from where you are the timestamp on the bottom of this?
No.
Your Honor, with the court's permission, it's very, very small. Is it possible to ask the witness to adjourn from the witness stand just to get close enough to see if you can read the...
You can't increase the size of it?
Maybe we can. I'm not the tech guy. Mr. Wolk?
Magic.
Magic. Wow. I didn't even know he could do that. Okay, can you read that?
Yes, it says rear lot cruiser side.
Okay, what about the time?
The timestamp reads 1/27/41.
Do you see a date?
Yes.
What is that date?
1/29/2022.
Thank you. This is my fault. Your Honor, if we could move back to rear lot main side, I'd like to do the same thing. I failed to ask for the time and date on that one.
This was all impeachment from Higgins' first trial testimony. This is all Brady material that should have been turned over. Yep, it's an hour late.
Is it possible to see from there the time and date?
Yes, the time is 1:27:32 a.m. and the date is 1/29/2022.
Thank you. Okay, if we can move to the third clip.
I'll pause this. No, he did not. He did not get into really any of the shenanigans when it came to how the video was collected and how it was produced in the drips and drabs late, and then, substantially a lot of it not until after the first trial was already done. This particular video, as I recall, was not produced until after the trial was already over. So none of that really elicited or developed in the cross-examination yesterday.
If we can start, Mr. Wolk, by enhancing with the court's permission the time and date, let's just start with that. Okay. Do you see what the timestamp designates this camera angle to be?
It appears to be church side. I can't read the third word there.
Exterior?
Oh, yes, exterior. Sally Port.
Okay, and if you could tell the jurors what you see in terms of the time and date.
The time is 1:27:43 a.m. and the date is 1/29/2022.
Thank you. Mr. Wolk, if you could play that with the court's permission.
Okay.
Stop. Do you see a person in that video?
I do.
Although it's somewhat blurry, can you describe that individual for us, please?
Individual wearing dark clothing, possibly. That's the best I could do, really.
Okay. Does it appear, given what you've seen in terms of the time of the main side, cruiser side, and now this exterior church side, does that appear to be the same person moving through on the outside of Canton PD?
It does.
Okay. And what are we looking at here, by the way? What is this door he's about to walk into?
I'd be guessing. I was never present on that side of the Sally Port.
Understood.
I don't know.
Let's go ahead and play this.
He's never been there ever.
Okay. And for the final clip.
I can't quite tell if he's wearing the same clothes or not.
If we could go down to the
I don't
time
have
stamp
this
and date.
old hoodie
This
on
one
at the
here in the
waterfall.
hallway.
Is it the same hoodie?
A little bigger, Mr. Walk, if you could. Can you see what that is designated as that camera angle?
Yes, it says first floor corridor, and the time is 1:28:03 a.m. on the 29th of January, 2022.
Okay. Is this the corridor version or video that you did have some recollection of?
Yes, this is, yes.
Okay, if we can go ahead and play this.
Now, guys, I'm going to pause
It's the
it.
same.
I'm going to pause it because I know I wasn't the only person when this video was first shown and he's walking in and I see this and I thought, that doesn't really look much like Brian Higgins, but just, shrug, whatever, shrug. Doesn't really look much like Brian Higgins. But it turns out that a lot of people had the same idea. It doesn't really look much like Brian Higgins. So I went and put together just a little bit of a comparison that I'm going to go ahead and share with you guys as well. Does it really looks so much like Higgins, but a lot of people think, boy, that kind of maybe looks like Brian Albert, maybe in the nose. Guys, I see it. Now, let's talk about what this means, okay? I did a poll that I'm going to go ahead and share as well. I did a poll, awful lot of people, 1867, not quite half of them think this looks like Brian Albert. I want to talk about what this means and why I pursued this. Of course, you can see this first little comment. Don't entertain this stupidity. This stupidity. People's eyes aren't stupid. And what people think they see with their own eyes isn't stupid. The reason why I think this is significant is not because I think this is Brian Albert. I have no reason to think it's Brian Albert at this point. If there is a reason to think this is Brian Albert, I got to think it would come out in the defense case and that they would explore that. Brian Higgins testified in the first trial it was him. It's Brian Higgins' key card. The person's wearing Brian Higgins' clothing. So don't necessarily have a reason to think it's anybody but Brian Higgins, except for, gosh, we watched this video. Look, here he is. And it doesn't really look much like him, does it? So why does that matter? The jury doesn't know who any of these people are at this point. So the jury has no reason to think this is anybody but Brian Higgins. But those of us who have watched this trial, followed it the first time, we've seen these people. Very common reaction here. Doesn't look so much like Brian Higgins. Does this perhaps speak a little bit to the misleading potential of video and photographic evidence? We have this idea in our minds that it's as good as gold. It's great for identification. It's clear. It shows you reality. Does this maybe begin to illustrate why video is often not necessarily that good evidence at all? Because a lot of people can watch a video and see the same thing or see completely different things. And if you take that principle and you think about it and you start applying it to some of the other evidence in this case, like, I don't know, taillights, maybe becomes clear why that isn't particularly good evidence. You think it is, you think, oh, it's captured on video. It's done. We can solve it from that. But it's not actually very good evidence. It's not as clear as you want. It can be very misleading. That's what I think this video here is really showing us. So I don't know if there's going to be any follow-up on this at all, if this is just something that is an interesting thought experiment for those of us who have watched the trial before. If this is something that the defense is going to, follow up on or pursue in any way at all. I don't have any reason to think they would. They haven't so far. How do you even believe your own eyes when this is the kind of stuff that you're dealing with? We got inverted video from the last time. We got taillight that might show white but might not. People see all kinds of different things on that tail light. They did last time, they do this time. And then let's not forget the shoe. The shoe with the white sole that looks black. Does this all like emphasize the importance of forensic photography? If you're going to rely on images to try to make a case and to try to draw conclusions, does this perhaps suggest why you can't just rely on regular cameras, bad light, squint at it? If you watch the Richard Allen trial with us, you probably already kind of got some of these ideas from the whole bridge guy video. This very grainy, pixelated, unclear image of a person. You can picture a lot of people fitting that guy. Apparently, many, many tips came into the tip line. Bridge guy is Ron Logan. Ron Logan, one of the neighbors. Many people thought that. Not a single person apparently thought, hey, that bridge guy looks exactly like Richard Allen, that guy that works in the pharmacy down at CVS. Guy that a lot of people would have had contact with, but apparently nobody called in the tip line saying, hey, you know, this bridge guy, he really looks like Richard Allen. And yet by the time we get to trial, a lot of people think, oh my gosh, bridge guy looks exactly like Richard Allen. Really should speak to how we have a lot of misconceptions about how good video evidence is. Because I don't think people are stupid for looking at this and thinking that looks like Brian Albert. Yeah, it does kind of look like Brian Albert. I agree. It does kind of look like Brian Albert. I don't think that means it is Brian Albert. I think it means video evidence is often extremely misleading. Let's go ahead and continue. Sweatshirt.
Do you recognize the person in this video?
It appears to be Mr. Brian Higgins.
Okay. And what is he wearing? Describe it for the jurors.
Black sweatshirt with some sort of logo on the front. It appears to be blue jeans and shoes with a white trim.
And is the hood up or down on the sweatshirt?
It's up.
Okay. Let's go and play this. Just a moment. Could you pause this, Ms. Wolf?
Good point, Lisa. As far as we know right now, all it proves is that Higgins lied about his timeline
note
in trial one.
Time as it's paused right here.
Do you want me to say it again or
Yes,
write
sir.
it down?
Yes, sir.
The time is 1:28:16 a.m.
Okay. And if we could just continue playing this video.
See, during trial one, Higgins says he left 34 Fairview almost immediately after getting there because they didn't have any Jameson. So I'm going to pause this real quick because we do now have an update from Ted Daniel a little bit anyway. Appears the cancellation of today's testimony was a game time decision. The prosecution team is here. Several people in the courthouse told me they just learned as well. So we are waiting to see if we find out anything else about why we are apparently not having court today. Rob here in the chat made a fantastic point. It'd be really easy to get an update from the lawyers. Yeah, it would, wouldn't it? If the lawyers could tell us anything about what's going on, but they're not allowed to make comments. I don't know. The gag order is a gag order this broad. It's the quote unquote gag order. I almost don't even like to call it that because I read it as really just reiterating lawyers have to follow the rules of professional conduct. You don't get to make extrajudicial statements that that the lawyer knows or reasonably should know would affect the defendant's ability to get a fair trial. You know, more or less that language. Would procedural stuff like this affect it? I don't know. I guess it depends on the reason. But makes it a little harder to get information than perhaps it should be. So anyway, I did just want to share that with you guys. Let's go ahead and go back to this new video. He had himself coming to Kent Police Department about 12:30.
Stop.
A good hour before.
Now, if you could take a look at the time now. Okay, what's that time?
1:29:42.
Okay.
a.m.
And if we could go ahead and go forward.
I'm going to pause here just because there are a couple people with comments about this. Jay to go saying, I seen people think it was Brian Albert and not Brian Higgins. A lot of people are thinking that. I understand. And I can see why. You know, my first reaction is sure doesn't look like Brian Higgins to me, but I don't have any reason at this point to think it's not. We know that the feds got Jen McCabe's location data. You know, they were able to track her over to Lank's house. That's how they found out. Is Jen McCabe the only location data that they got? Seems a bit hard to believe. They can get that from the phone records, the call detail records. There was they were having a sidebar during Jen McCabe's testimony. And of course, we can't hear the sidebar, but sometimes it'll pop up the closed caption. And what came up on the closed caption? Tracks. Now, am I 100% certain that means they're talking about Sci-Ray's mapping software tracks? Not 100% sure, but sure is coincidental. Seems like a very real possibility about what was under discussion. And that's taking the information that's provided in the call detail records, which is something that investigators get from the phone company. It gives them the ability to plot the location of the phone and map its travel and so forth. So they seem to have been able to do that with Jen McCabe. Possible they did that with these other folks. Seems possible to me. I don't know if we know one way or the other if that happened. But I, would expect. Why would you not? If these folks are under suspicion, and that's information that's available to you, surely you would do that. And if you had done that, surely the defense would know about it. And if the defense knew about it, then I would have expected that would have come up in the first trial. Because the defense would have been able to point out, Mr. Higgins, you said you went to the Canton Police Department to move cars at about 12:30, but your phone data doesn't support that. The phone data doesn't show you going there. If there's an inconsistency there, I would have expected that to already have come out. So I understand. A lot of people think it was Brian Alberts and not Brian Higgins. I think that speaks to reconsider how valuable video evidence is. We want to think it's really good evidence, and it's often not. It is often not. It is often very misleading. It is often very subject to interpretation. I think that's exactly what we see with these taillight videos in the case. Look at that video of the car leaving John's driveway, the 507 video from the Ring camera. Commonwealth is absolutely insistent that shows a white light coming from the side, a broken taillight. But then we look at that inverted Sallyport video where we're seeing what looks like the passenger side taillight, but is in fact the driver's side taillight. And tell me that doesn't look real similar? Looks real similar. The tow video looks real similar. It's not very good evidence, guys. That's just really the bottom line. It's not particularly good evidence. This comment from Leo, thank you, Andrea from UK. Corridor vid, is he wearing gloves? Looks like latex gloves. Also hood up on arrival and indoors, then hood down after in blizzard. Weird. Yeah, that was another thing that people caught on to think this looks like Brian Albert is when we get to the point where he's back out in the parking lot, he's wearing the hoodie. And we've never seen Brian Higgins in a hoodie, but Brian Albert is wearing a hoodie in that waterfall video. Hood up inside, but hood down outside. Yeah, I could see that being weird. Not necessarily what you expect. So, Rob, if all the foundational testimony suggested Brian Albert went to Canton PD that night, your eyes would tell you that's Brian Albert, confirmation bias. Thank you, Rob. How you interpret how you interpret evidence depends a lot on what your expectation is when you're looking at it. Agree 100%. That's why people can see so many different things in the video. People who expect to see a broken taillight can watch a lot of that surveillance video and they see a broken taillight. You expect to see an intact taillight? You can watch that video and see an intact taillight. It's not particularly good evidence. It just is something that allows you to project your expectations onto it. There's no foundational evidence that this is Brian Albert. None. But sure doesn't look like him, does it? And I got to agree. That was my first thought when we're watching this video. Yeah, it doesn't really look like him. Nick Starrow, to be honest, it's Massachusetts. At least 20% of middle-aged men look like an Albert. And we said the same thing about Bridge Guy. Bridge Guy looks like 90% of guys in a Cabela's in Indiana. Do they even have Cabela's in Indiana? I'm not sure if they do. But inside like the ranch and home store, the hunting section, every other guy looks like that. How on earth are you going to say, oh, this is definitely Richard Allen on this video based on Bridge Guy? Every other person there looks like that. They look very similar. Brian Albert and Brian Higgins look very similar. They got the same facial hair, They have a little bit of different face structure, but the hood's up. You're not going to see. Okay, Brian Higgins has kind of a fat face. He's got a little fat face, a little chipmunky. You're not necessarily going to see that with a hood up. Hood can give you shadows, give you the impression that, oh, this looks like more of a thinner faced person, maybe more like Brian Albert. That can be deceptive. Duncan, Idaho, not even slightly suspicious, walking around inside the station hallways with hood on and drawstring pulled. I mean, fair point. Fair point. I like to wear hoodies. They're convenient when it rains a little bit, it snows a little bit. But yeah, as soon as you get inside, I mean, it feels like it's almost automatic. You pull that hoodie off. And what's that hoodie over your head when you're inside? I don't know. So these are good points. Lock Hong Express, please look at the door frame. It's bending. We can see that right here. In this frame right here. It's distorted. Now, is it bending? Look across the wall. Look at the photos on the other wall. Those are also quote unquote bending. This is lens distortion. This to me looks very clearly like it's lens distortion. This is the type of thing that happens when you are up close to something with a wide angle lens. Yeah, guys, cameras are not the reflection of reality that we think they are. They really aren't. BT, can we do gait compare? Plus this shoe had red tab. I don't know if we have gait comparison. So what I saw when he's first walking across the parking lot, right? We see that terrible posture. Okay, that head forward posture. This to me screams desk job. This is the posture of somebody who sits at a desk all day. You end up with this head forward. Your back is weak. And then the same thing with the gait, with the walking that we saw in the hallway. Called it out yesterday. The left leg in particular kind of swings out to the side instead of just moving straight forward and back. That's a sign of a weak hip flexor. Weak hip flexor, also very, very common with a desk job. So this gait screams to me somebody with a desk job. I don't know. Brian Higgins, Brian Albert, more active in the field. Brian Albert's on the was on the fugitive apprehension team, right? He was out in the field arresting DOC guys. Meanwhile, Higgins is the ATF person with the satellite office in Canton. What does he even do? I don't know. Just kind of on face value with those descriptions, sounds to me like Higgins is more of the desk job guy. So this would be more consistent with him. but we don't really know. We don't really know. Let's
Is it still playing, Mr. Walker?
you.
If we could take a look at the time one more time.
Now it's, you want me to say it?
Yes, sir.
1:34:12 a.m.
And in the time, just so the record's clear, in the time between you saying 1:28:16 to 1:34:12,
Lost about 5 minutes.
6 minutes has not gone by, correct?
Just under 6, I believe, yeah.
Well, 6 minutes for us in real time.
Oh, in real time, yeah, no.
It is not. So it
Sorry.
appears that the camera jumped, or the time jumped.
The time difference from what was displayed is approximately 6 minutes, yes.
Okay, which is much longer than the time we've actually been looking at the video, correct?
That's correct, yes.
Okay, so it appears that it may be motion activated and it just jumped.
That's a possibility, yes.
Okay,
yes.
let's go ahead and continue playing this. And stop. Do you see someone in the screen now?
Yes.
And one more time, I know this is laborious, one more time if we could clock the time.
Just a few short minutes later.
Can you see that?
No, it's really blurry for me.
Inside the CPD
Yes,
for about 5
now
minutes.
I can see it. 1:34:15, if I'm not mistaken. AM.
Okay, fair enough.
Another comment here I want to bring up real quick. Steve F. Not only is video evidence problematic, as you pointed out, but digital video evidence is much more manipulable than analog video, as we've seen. We just watched a time jump. And are we taking it on faith that that's because the camera is motion activated? Perhaps. Mr. Jackson seems willing to accept that interpretation. Do we know that? I don't. Seems like the most logical interpretation of the evidence, but is it the only interpretation of the evidence? No. And we see in the Sally Port the problems in that video with the apparating people explained as well. It's a motion activated camera, but people are coming in and out of the frame, on the middle of the screen while there's action taking place. Really doesn't seem to provide a very satisfying explanation in light of what we can see with our own eyes. So yeah, there's also potential for manipulation of video. We've seen manipulation of video, indications of it in this particular case. They testified to it in the last trial with that one backside view of the Sally Port, the one that we watched yesterday. And, the bad camera, the one that shows the antique police car in the background. In the first trial, they testified about, they took some steps to enhance it, tried to see a little bit better what's on that video. Yeah, we know they do stuff like that. We know that that's possible. So, not only is it not particularly good evidence because you can't necessarily believe your eyes, you can't necessarily believe what it's purporting to show you either. It's not that hard to manipulate it.
And let's go ahead and play this all the way through.
It's a Harley Davidson hoodie.
Okay.
There's
Who
that
did that
gate.
appear to be walking away from the camera in this shot?
I'm not certain. I would be suspecting or guessing if I gave you an answer, but I'm not certain who that is.
As best you can determine, does he have the same stature? I know you can't see his face. Same stature, same clothing, jeans, shoes with white stripe around it, dark hooded sweatshirt. That should appear to be the same person as Brian Higgins.
It does appear that way, yes.
Okay.
Does appear to be Brian Higgins.
Okay. There's one more clip.
Defense is really not suggesting it's somebody else.
On the same GG device.
That walk where he's swinging his legs out, that's a weak hip flexor walk. He's swinging him around instead of pulling him forward.
What do you see in this video?
Appears to be the church side Sally Port, and an individual came out of the door.
Gonna pause this real quick for a couple others. Duncan, Idaho, have a desk job, and it's far more perilous to my health and posture than mail carrier me would ever have imagined. Have to actively fight the decline. I hear that. I mean, I told you guys after the first week of just sitting here watching this trial for however many hours a day, I got to pause. I got to take myself off camera from time to time so I can just get up and move. Sitting is the new cancer, man. It's terrible for you. It's absolutely just lethal. Really bad for your health, so bad for your posture. If you have a desk job, I had a desk job for many, many years. Really does take a little bit of active work to combat it. And boy, the older I get, like the harder it is to make up for the damage of just sitting and sitting and sitting. Alyssa Ramirez, what was the key card log in evidence for this time frame? Anyone remember from last trial? Was this deleted? I don't believe it was deleted. Trying to remember where it came out. I don't recall that there was any indication of a problem with the card log. They did seem to have evidence of Brian Higgins's card swipes. It was Brian Higgins's card that swiped them in and wherever they went. I think the issue as they developed it in the first trial had been trying to nail down if they could show Higgins' card swiping him into the Sally port. They were trying to see if they could show Brian Higgins had ever obtained access to the SUV while it was there inside the Sally port. I don't think that was ever able to be confirmed. So they had asked questions about, oh, well, if somebody else swiped and then held the door, kind of thing. Just holding open that possibility. So as far as we know, I believe the key logs show that it was Higgins. Higgins's key log. Gina Brown says someone else is in Higgins's Jeep in Canton PD after bag is put in Jeep and Higgins walks to the truck. Watch the Jeep's driver door. So we'll pay attention to that when we get back to that part in the video. There's a lot to see on this, a lot to try to follow, and you're focusing on one part of the video, something else is going on in the other. I didn't see the car move the first time. I didn't see the plow on the front of the Jeep when it came in. It just depends on what you're focused in. So that can be something to pay attention to.
And can we highlight the time, please, or increase the size? What time do you see there?
1:34:40 a.m.
Okay. If we go ahead and play this through.
He's on the phone, isn't he?
Does it appear from this video that the person has anything in his hand?
I'm sorry, can you play that again? I wasn't looking at the hand, but
Sure.
I really can't tell.
Okay.
I can't tell. It looks like he's got a phone, doesn't it?
There should be another video of the rear lock cruiser side. Let's take a look at that.
Now, here's a question too, because we know that they have the call logs. We know the defense has the call logs for both Brian Albert and Brian Higgins. Why? Because they were both confronted with them in the federal grand jury, had to explain the butt dials. We know that they had the record of the butt dials. So what do the phone records show about phone calls on either of their telephones at this point in time? Well, you know who would have that if it's out there? I'm pretty confident that Sleuthy Goosey would have that. I don't know if we've got record. I don't think she tracked. No, we've got Jen McCabe's communications and we've got John's communications. We've got Jen's outgoing call to Brian Albert at 6:23. That's because it's from Jen's phone. So I don't know that we have a good account of who was making what calls when. We have that 2:22 phone call. Brian Albert calls Brian Higgins. It lasts for 1 second. And then 2:22:17, Higgins calls back. It's answered, and there's 22 seconds. That, as far as I know, is the only information that we have about Brian Higgins or Brian Albert being on the phone this morning. And it's an hour after this. It's an hour after this. So that to me is a little bit peculiar. Do we not have a phone record for Brian Higgins to confirm? I mean, it seems that we don't. He had denied it at the first trial. I think defense had specifically asked him, "Did you make any phone calls?" That's why this came up as this video being potential impeachment. One of the many reasons, because there he is on his telephone. So if they didn't know from a phone record, what phone is this? What phone is this? Question here, what rooms at Canton PD did BH access? Also, if it is BA, what does that mean about his involvement? Could BH have been cleaning himself up? I don't know that we know specifically at this point what what rooms were swiped into, what areas needed that card to be able to grant him access once he's in. How much is open versus how much needs to be card swiped in? I'd love to know that room we saw him going in from the hallway. What room is that? It's got a sign outside the door, but I can't see what the sign says. Somebody that's familiar with the Canton Police Department knows what room that is. What room is that? To me, a lot of this is highlighting what I think is I just have, I guess, a little bit more confidence in the prediction that the defense is gonna call Brian Higgins. I mean, I think the defense is gonna call Brian Albert as well. They got to get these butt dials in. The butt dials when they're not supposed to be on the phone and when they have denied being on the phone, seems significant, goes to guilty knowledge. And I don't really see a pathway to get that information in without calling those witnesses. But Brian Higgins now. Are they going to ask him to explain this? You testified in the first trial that you were there to move cars. We can see the video. You're doing other things with cars, but not seeing cars in general, cars plural, being moved around to make room for a plow. Really not seeing that. So what are you doing in these cars? What room is that you went into in the Canton PD? I do wonder about that. If it were BA, I have no idea. The defense would elicit it. If they have a reason to think this is Brian Albert, I gotta think, yeah, that's going to come up in the defense case. So would they know? I have no idea, guys. I really don't. I really don't. There would have to be a theory. There would have to be a theory. So continuing to keep an eye on the information about what's happening in
What do you
court.
see in that video?
It appears to
Phone
be an
lit up by his
individual
ear.
wearing a black beanie hat, black dark colored sweatshirt with some design on it, and something illuminating by his face.
So this right here is the other point that folks who think maybe this isn't Brian Higgins are pointing out. Hey, look, he's in that beanie. Like you guys said, weird. He's got the hat on inside, but now he's outside in the snow, and the beanie and the hoodie is down. But he's got this beanie on, and we haven't seen Brian Higgins in a beanie, but we have seen Brian Albert in a beanie. I get it. I don't know that convinces me that this is Brian Albert, but I can certainly see how people would be asking that question.
Can we enhance the time, please? What time is that?
It says 1:34 and 53 seconds in the morning, AM.
And if you could move the screen over to the individual. Well, does that appear to be the same person?
It could possibly be, yeah.
And does it appear as something in his hands up to his face, the right side of his face or ear?
Yes.
What do you think that is?
It's consistent with a cellular device, possibly a phone or a tablet.
Okay. If we can move on, please. Play that through. I believe there's one more video.
This is the long one.
And Your Honor, this one is a little longer. This is about 10 minutes.
Okay.
With the court's permission, I'd like to play this through. Please stop. Do you see a person in the video walking from screen right to screen left?
Yes.
Did that person appear to have something in his right hand?
I can't tell. I can't see his right hand.
Okay. When he first walked into the screen, could you tell?
I couldn't. No, I'm sorry.
Mr. Ward, could we back that up with the court's permission? About 2 seconds. Stop. Does it appear as something in his hand?
It's a possibility, yes.
Okay. And just for, I'm going to ask you for 2 times when we start and when we stop. What's the time on this video at this point when he walks in the frame?
1:35 and 8 seconds in the morning, AM.
Okay. And let's go ahead and play this through.
We're going to watch him sit there on the phone and then drive away, and that's going to completely contradict. This is a terrible place to pause, but while we are on the subject of video being misleading, boy, if I back this up, like, I don't know, we can't really tell. Now it's going to buffer on me. Just a few seconds. The sweatshirt, guys, does that look like a black sweatshirt? It doesn't. It looks like a white sweatshirt. We don't have any reason to think it's a white sweatshirt. Oh, great. Now we're going to play this game. But again, it just speaks to video not being
sit there on the
particularly
phone
good. Yeah,
and
see
then
there, look at
drive away, and that's
It doesn't
going to
look black.
completely contradict his testimony from the first trial about how long he was there, what he was doing, etc. That's going to be my guess.
Anyway. So this is where I kind of lost him. It's hard to see. Where did he go? Where is he? He just kind of vanishes over behind that Jeep. Then we see in that back corner now,
I can't believe they caught him with
middle of
the
the
screen all lit up. No
The thing that looks
denying
like-
that is a on telephone.
Looks like maybe an old muscle car. You know, looks like an old Chevelle or an old Plymouth or something like that. It's got that racer back. It's just kind of what it looks like. That car is moving in the meantime, so that's the only activity going on the camera.
Phone being held up to his face.
That car has been backed up. Now it's just sitting there.
That is
Looks
indeed exactly what he said. His reason for going back to the Canton Police Department around 12:30, according to him, was because he had ATF vehicles, work vehicles that were parked in the parking lot, and he needed to go move them so that they would be able to plow the parking lot. And that's why he went back to CPD.
That car is just sitting
So
there
I'm
now.
kind of guessing this video is going to show none of that happening and him just being there for what, 6, 7, 8 minutes, talking on the phone, and then leaving in his Jeep. But we'll have to wait patiently to see.
So it looks like, okay, now the car moves. Now the car seems to leave, go somewhere else. Definitely out of the frame. So he went around the passenger side of the Jeep towards the back of the Jeep, and we have not seen him since then. He hasn't come into view. So he didn't come around the back side of the Jeep towards the driver's side. We haven't seen him over to the left of the video. As far as we can tell, he's still back there behind the passenger kind of rear corner of the Jeep. I saw the car move, but I sure didn't see him get in the car. Back out. Anybody catch him getting into that car? I didn't see where that car came from. He moved a car behind the Jeep. Now here he comes from the opposite side. There he is coming back. Okay, so he went around the far side.
A person walking into the frame into the video from frame left to frame right?
Yes.
Okay, go ahead.
What an idiot. She didn't even see the car move in the back. You're right. I did not. Thank you. I mean, God, what a moron. What a moron. Hip abductor weakness. Thank you. Not
Did
the
we
flexors.
see what car got moved?
What kind of idiot thinks it's the flexors? Now he's moving over towards around the back of the Jeep, towards that truck that's parked next to it. Door opening, headlights on. Now he's getting into this truck over there.
Can you pause it? Did you see something happen with the vehicle next to the Jeep in the last few seconds?
Yes.
What was that?
It appears as though the headlights are activated.
Okay, let's go and play it.
Now the door closes.
Okay, pause it. Do you see a person that is walking from screen right to screen left in the middle of the screen?
Yes, he just or she just appears to have closed
Or
the door
she.
on that vehicle next to the plow.
Okay. And walking toward which vehicle?
The one on the furthest on the left.
Okay, from what you've seen, Sergeant, you said he or she, does that person appear to be consistent with the video that we've seen of, in other particulars, of Brian Higgins?
As far as I could tell from here, the individual accessed Brian Higgins' vehicle, so I'd be speculating with the whiteout conditions or near whiteout conditions. It's tough to tell.
But no reason
This
to
is
believe
near
it's anybody
whiteout?
other than Brian Higgins walking with
See all the way to the back of the lot.
No.
Let's go ahead and play it.
Now he's getting into this car that
And what do you see Brian Higgins or that person doing now?
looks like a truck with a cab
He
or a
accessed
large
the
SUV,
vehicle
like an
on the far left.
expedition or something. I mean, is this not sus enough?
And where's that person going?
Now they're accessing the Jeep Wrangler.
What is this? What is this shuffle?
Oh, is he putting something in it?
Didn't see anything in his hands in that section.
What on earth is he doing? This is very confusing.
But he seems to be clearing off the back to like look in the window. But it's very hard to tell because the video is so bad.
Is he cleaning off the windows?
No, it looks like he got a duffel bag, right? Was that where it looks like he has the duffel bag? Guys, I'm going to make it buffer again. Sorry about that. It's just what we're going to be. Try it one more time. Looks like he's carrying a duffel bag or something. Hard to see. Video isn't very good. You can kind of see whatever you want. But does it look like a duffel bag? Give us a minute here to buffer. I don't know why. I don't know why it does that every time you try to take 5 seconds back. Okay, here we go. There it is. See, doesn't that look like he's got something on his back? But it's very hard to tell. This is exactly, unfortunately, what I did do. It is what it is. Could very well be on my end. Now getting back into the Jeep.
Sitting there in the blizzard with the Jeep door open.
How many times can I overspeak
Where does that
myself?
individual appear to be now in the video?
Last I could tell, they might be by the Jeep Wrangler.
Before that person got to the Jeep Wrangler, is he standing by the vehicle on the far left, SUV or truck?
It appeared that way, but with the heavy whiteout snow that night, I can't tell exactly what they were doing.
Did you see anything in his hand, like a bag or a satchel or a duffel bag or something when that person walked from this vehicle over to the Jeep?
I did not notice, no.
Go ahead.
Yeah, it did kind of look like that. I can see why you would think it looks like that. Now the Jeep headlights are on and coming
One
back.
thing he is definitely not doing is moving a bunch of cars.
Not moving them. You see the one car move. And that's it.
Now, has that person walked off screen to the left?
Yes, sir.
Okay.
That looks like a pickup with a cab cover on the back.
That's what it looks like. It also, like I said, it
You know,
looks like it could
canopy.
be maybe a
Can't tell
big
what kind though.
SUV,
Entering screen from screen
like
left.
an Expedition.
Yes.
It's the in and out of the cars is so bizarre. Now off the screen.
Now the Jeep lights are on.
Got something long looking in his hand there.
What did you see the person do?
They were carrying possibly like a snow broom, walking from left to right.
Possibly like a snow broom. I'm not sure I know what a snow broom is. I know what a snow shovel is. Is there a special broom for snow?
And what do you see happening now?
The Jeep Wrangler's leaving the spot it was parked in.
Well, pulls
about
away.
145.
Put that down.
So, guys, that was our new evidence. That was something brand new from the first trial. What does it mean? What does it mean? I mean, that is really the $1 million question. That's the $1 million question. It's very peculiar. I find it very strange. Can't really see what he's doing. Certainly understand the perspective. Folks look at him in the hallway, think that doesn't look much like Higgins. But then we also see things like he's walking across the parking lot and the sweatshirt looks white. Pretty sure it's probably not white. It's bad video. Very hard to know what you're seeing and what you're not seeing. And I think it just, again, speaks to the difficulty of trying to build a theory or develop a case out of video evidence. A lot of the times it just may not be showing you what you think it shows. There's a Ford Edge looking car in the parking lot too. See, okay, I told you guys, I don't know what a Ford Edge is. I've never, I don't think even heard of a Ford Edge. So I had to look it up. And this is apparently, let me get a good image I can share. I don't know if we know what model year we're looking for here, but let's see. Oh, that's not what I want. I don't know why it's giving me trouble pulling up an image right now. Oh, let's say like a 2020 Ford Edge would be this one here. Let me try to get it pulled up. All right, here we go. Here we go. That's a 2020 Ford Edge. Looks like it's got a little, lip kind of thing in the back, kind of like Karen's. Doesn't look like a particularly large SUV. Got a few different trim models, but this looks like, I mean, you guys will have to tell me, this looks like maybe Subaru Forester sized. You can kind of see the guy in the driver's seat in this photo. This doesn't look like a particularly large SUV. It's a 2-liter 4-cylinder engine. The bigger one here, the ST is a V6. So if it's a 4-cylinder, that doesn't seem like that's a very large vehicle either. That's what we got for the images. I don't know if it's a 2020 we're dealing with or not, but just to get us back, not a 2024. We certainly know it wasn't that. So, I don't know. That large SUV that he was getting into, or the pickup with a canopy, whatever it was, that looks too large to be a Ford Edge to me. The pickup truck right next to him is a pickup truck. Didn't see anything that I could say, clearly is a Ford Edge looking. I didn't really see anything that size real clearly, but I don't know. Let's see. See a couple folks saying Higgins in the microdots video, the lead up compared to hallway video taken in same 24-hour period. Higgins has little facial hair at the bar, if any. Let's see if we can maybe pull it up. Here's some of the video footage at the bar. We'll take a look at that. Just a quick look at Microdots' video. I mean, it looks like that's Higgins in the middle, right?
Authority and seeking his approval. But Chris steps squarely in front of Higgins and puts both of his hands on him again. Higgins is rattled.
We can kind of see
Brian raises his palms facing upward, a universal gesture of confusion, questioning Chris's protest. Higgins continues to fix his gaze on John, peering over Chris's right shoulder. Meanwhile, Chris stands in a posture strikingly similar to that of a bouncer step. Chris.
Try to skip it a little bit so that we can
prompting
see.
Chris to release his grip on Higgins' left arm for the second time. Higgins stares blankly. The two men exchange a few words as Chris gestures towards the exit.
I don't know what we can see here, guys. Can we see? I mean, can we see? Is this clear enough to see facial hair one way or the other? I'm not sure that it is.
Chris is trying to assist Albert as he intervenes. Brian challenges Chris's position with his voice and body, causing Chris to throw up his arms in frustration.
Yeah. I don't know, guys. If you guys want to look at more of that video, go check out Microdots to see. I don't want to play his whole video. I'm not going to do that. But feel free to do that comparison if you want. To me, it's not clear enough. None of this video is really clear enough to be able to say one way or the other. It speaks to how bad video evidence is, even though you may not think that. It may seem intuitively like it's a great source of information. Just not sure you really see what you think you might be able to see. So it looks like there might be some new information up. I'm seeing several comments. Let me go ahead and share some of these. Jess Machado, a credible source, says Karen is sick. I will update below if I hear anything else. Looks like this is the email that went out from the court today. Good morning. Please be advised that the trial in Commonwealth versus Karen Reed is not taking place today due to unavoidable circumstances. Best regards, Jennifer. Jennifer Donahue, the court spokesperson. What else do we have here? I see Turtle Boy is saying in-person court today is canceled. I'm hearing rumors that they're going to be on Zoom at 11, but nothing confirmed. That doesn't seem consistent with the email from Jennifer Donahue that we just saw, just that the trial is not taking place today. So don't know what any of that means. I see some folks in the comments bringing this up. Karen Reed is ill, apparently. That could be. That is sometimes an unavoidable circumstance that can come up in the middle of trial. People are unable to attend. So, I mean, that's possible. I think that's consistent with the information. Don't know at this point, one way or the other. Sandra, Aiden K's tweet about Karen turning state witness is a joke. It's not real. I would imagine it is. Karen is not going to turn state witness against herself. I didn't see this particular tweet, but maybe some of you guys know what that's referring to. So let's see what else we got. Yeah, this is what I've been doing. I've been using the arrow keys. It doesn't go frame by frame. It goes 5 seconds at a time, forward and back. I think you can also do that with the J and L keys. I don't typically use that one, but if people are sitting there, with your fingers on the keyboard like you're typing, it's just your right hand ones. Now, JC now has this is good info. I didn't know this. You can use the period and comma keys to move back and forth frame by frame. I will try this next time. I didn't know there's a way to go frame by frame. I will give that a shot. So the Traveler says Turtle Boy has court today. Can we cover that? I don't think Turtle Boy's court is shown on like Court TV or Law and Crime or any of the streamers. And so I think it's on Zoom, and you're not allowed to restream the Zoom. So I won't be doing that. But if anything comes up and we are still going, we may hear about it. So we will just kind of wait and see what's going on. James Casatelli, one of the stadies outside the courthouse, made it onto Lackluster's channel last week. That was pretty awesome to see. I don't know Lackluster's channel. But stadies getting famous, perhaps for the wrong reasons. Is that what that's about? Miriam, I'm behind on live right now, but could it be about the buffer? I don't think so. That's not really an unforeseeable circumstance. I think the folks suggesting it might have to do with sickness. That sounds plausible. Sounds plausible. That is definitely, nobody plans on being sick. Nobody plans on being so sick they can't go to court. So I can see that being an explanation. The buffer zone is foreseeable. They've known about that since Friday. So I don't think it's probably about that. Carolyn Smith, Court TV, saying no Karen Reed court today. What's going on? We're waiting to see if we get more information. At this point, that is all we know, is just that there's no court today due to unforeseen circumstances. Alyssa Ramirez, chances John O'Keefe's family was surprised by these videos. Would they have known Higgy was lying last trial? I'd be pissed at DA. Well, I mean, that's a question, isn't it? Because at what point was anybody in the Commonwealth, including the investigators for the Commonwealth, at what point were they aware of these videos? It's very hard for us to say because we've got so many different explanations about where these videos came from, when they had them, and so forth. First, they were just sort of selectively extracted, and there's the 30-day overwrite, so you can't go back and get the old stuff. But then we started getting the old stuff, and then we heard somebody downloaded the entire section in 6-hour segments. But is that just the Sallyport video, or did that involve these other cameras as well? Very unclear. It's all very, very unclear. It shouldn't be that messy. It really shouldn't. It shouldn't be so hard to know where a video came from, who had access to it, when they had access to it, when it was produced, whether it was produced. This stuff should be really easy to document by people who have as one of their primary functions documenting evidence, documenting who has access to it, where it came from, when you got it, etc. Really shouldn't be rocket science. But that's almost part of the point. It's to obfuscate. If they wanted to clarify it, I feel like they could. And so the fact that they're not clarifying it, instead we're just getting all these different stories, that is to obfuscate so that we don't know. And we have a million questions. When did they have this video? Who got it? Who looked at it? Who knew that this existed? And would they have communicated that with the O'Keefes? I don't know. I would think in a normal world, normal universe, normal courtroom, normal prosecutor's office, no, they wouldn't know. Like, I don't think it's really conventional to sit down with the victim's family and like show them every piece of evidence in the case. The victim's family, they will have rights under the victim's rights statute, or sometimes it's a constitutional amendment. It is in Massachusetts. And so that typically, we've talked about it before, gives them rights to things like prior notice of court proceedings, the right to be able to attend if there's going to be a plea negotiation, a plea offer, something like that. They get to be aware of it, but it doesn't give them any particular rights in terms of controlling the process. They don't have a veto. They don't have a right to direct that the trial be conducted in any particular way. So they have a little bit more rights to the public, but not necessarily when it comes to access to investigative information. And so remember, like if you, the public, are sending, for example, a FOIA request or a public records request to the Canton Police Department asking for this video, you're probably not going to get it. They're going to tell you, no, this is exempt from disclosure because it's part of an active investigation. It would potentially jeopardize an investigation for this information to be disclosed. So they're not going to show it to the public in general. And the O'Keefe family doesn't have any greater rights than the public in general when it comes to being aware of investigative materials. So in a normal world, we'd say no. If the public doesn't get to see it, the O'Keefes don't get to see it either. But I don't know. This isn't a normal courtroom. This isn't a normal prosecutor's office. I really have no idea what to think of it. Miriam Generaco posted a tweet saying Karen is not feeling good today. Looks like a couple folks have that information. It is a plausible explanation for why we are not going to have court today. Miriam, also love you, Mom. I'm going to take it that is your mom, not me. I'm not mom. I'm not mom. I'm more like the cool aunt. Am I not the cool aunt? It's so much better to be the cool aunt. Jessica, one reminds me of Missy Bevers. Two all have Nike shoes. Yeah, that video. Is that what we're seeing? We're seeing more Nike shoes? I mean, I don't know. I don't even know what we're seeing at this point in time. KH, a body of men holding themselves accountable to nobody ought not to be trusted by anybody. Thomas Paine, Massachusetts, LE. Yeah, this is a great quote. If you are not willing to be accountable, then you shouldn't be trusted to be responsible. That's what it takes. It takes trust. If you're going to give somebody authority, give somebody power over other people, you have to be able to trust them that they're going to be responsible with it. And one of the ways you do that is looking at, do they hold themselves accountable? Because everybody makes mistakes. Everybody makes bad decisions. Everybody does things that sometimes they wish they had done it differently. And when it's just you and you're the only one affected or whatever, maybe it's not that big of a deal. But when it comes to how you are treating other people and your power over other people, in your exercise of that power and you make a mistake, are you willing to be held accountable? It says a lot about your relationship to that power. It is funny that you bring up the Thomas Paine, because I was catching up on History on Fire the other day, and it's been a while. I'm way behind. One of my favorite podcasts. And he did a series on Thomas Morton. Thomas Morton was the founder of Marymount. What was it called? It was a civilization in New England in the Massachusetts Bay Colony, but not a Puritan. Not a Puritan. Very much not a Puritan. Much more liberal perspective on religious rules and sins and things like that. Also a little bit more liberal perspective on relationships with the local tribes, how we should treat the natives in the area. And ultimately is run out and the civilization destroyed by the Puritans. And it was kind of funny because I've always had this perspective on Massachusetts as being one of these font of liberty colonies, the John Adams defending the British and so forth. Paul Revere, like all these kind of legends coming out of Massachusetts. But then I think back on like Salem and the Puritans and Thomas Morton. There is a root of tyranny there in Massachusetts as well. There is that culture there where maybe it isn't so much, tyranny in general is bad, but just the king's tyranny. You can definitely look at some of these Puritan colonies and see there's some roots of their own tyranny in there. Maybe it's not that they don't like tyranny in general. They just want to have that power for themselves, not held by the king. Anyway, it just, gave me a little shift in my perspective on Massachusetts because of the timing of that coming up. James Cassatelli, didn't Higgins have a proffer from the first trial? Could that have something to do with today's cancellation? He was definitely proven a liar yesterday. Don't think that would be unforeseen. I don't know that has to do with today's cancellation. So the story about the Higgins proffer, that comes from an argument that was made during pretrial hearings, and David Yannetti referred specifically to a proffer. And so we've never had confirmation one way or another that he's using this as the term of art that you often, if you are dealing with criminal defense, particularly in the federal arena, that you would understand a proffer to be. It's not totally confirmed that that's what he means, that he means technically a federal proffer. So in federal, criminal process, not uncommon if there's like a plea negotiation or something like that, there's going to be cooperation. There's going to be some type of cooperation agreement. I am going to give you, the feds, information. It's often in the context of a proffer, and typically that goes hand in hand with some type of immunity agreement, a limited use immunity agreement. Meaning that we can't use your particular statements against you. Sometimes the immunity can be more broad. It can be a derivative immunity type of agreement where basically we can't, even if we could use your statement to get new evidence, we can't use that against you either. Like nothing related to this incident can be used against you. Often go hand in hand with the federal proffer. And then the proffer is basically the information that you are providing to the feds. So if you're in that very specific context, proffer, it raises your ears perk up when you hear proffer, because it does. It's a term of art in that context. It implies some type of cooperation, often in exchange for a benefit, immunity of some type, an agreement not to prosecute. So it was David Yannetti's use of the word proffer in pretrial hearings that, led to this idea. I tend to think it's not a coincidental word that he used. David Yannetti, he is a criminal defense lawyer. I have a very hard time believing he's going to throw out the word proffer and not mean proffer, that he's going to mean, something else. So that has long been suspected, but we don't know. We don't know for sure. I don't think it's ever been confirmed. It didn't come up in his cross-examination or anything like that in the first trial. So maybe it was just casual use of language. Maybe he was using it in terms of at a state level, a proffer might be more like an offer of proof. I'm trying to get the court to do something. I want to make a record. Maybe the court's agreeing with me. The court's not agreeing with me. The court wants information to be able to evaluate my argument. So I make a proffer. Here's what I want to present to the jury. Here's what I want them to know. Possible he's using it in that context. Didn't really make sense in the context of just what he was saying, but this has never been confirmed one way or the other. So we don't know if Higgins gave a proffer, and I don't think it would be unforeseen. If it was something that we knew about, then seems like it would have come out at the first trial, doesn't it? I don't know. I just don't know. But I don't think this would be unforeseen. Amelia Walsh, Law and Crime, said the O'Keefe family were there and the Commonwealth lawyers, none of the defense or Karen's family. I have not heard any reports about Karen's family being present. It looks like here's another comment that somebody has brought up. Our 7 News crew reports that though state police were in place, there was no sign of the defendant at the courthouse this morning. So this is looking potentially like a viable explanation. If Karen never showed up, Karen is sick, that certainly can be unforeseen, and that can be the kind of reason why things come up in trial sometimes, and you have to adjust. It's not completely unheard of. Buffy, I was behind in feed last night when I heard you reply to my comment about Garrett Wing. I had no idea he was hired as an expert. Amazing get. He believed in Karen before being hired. Yeah, he did his own video on his own channel, and he was on Melanie Little's channel as well. I did an interview with her. So yeah, they had to litigate it to get him in. The Commonwealth opposed him being able to testify. This was the motion where Alessi delivered that little bit of a smackdown to Judge Cannoni. Hey, before you had issued this ruling saying that David Crosby was going to be able to, I keep calling him David Crosby. He's not David Crosby. I can't remember his first name. Crosby, Dr. Crosby, PhD Dr. Crosby. Before you issued this ruling saying that he was going to be able to testify about injury causation, we were operating under the standpoint that only medical doctors can opine on injury causation because that's what you said in the last trial. But now that you are applying this new standard, we have gone ahead and identified Garrett Wing, and we're going to present stuff through Garrett Wing. So went through and litigated that as well. The Commonwealth tried to keep him out. Judge Cannoni said, no, it's allowed. He's going to be permitted to testify. So I am excited to see what Garrett Wing has to say when we get to it. Fighting Usyk, BA giving BH abdominal thrusts at the bar was foreplay for the later butt dials. The abdominal thrust was a little bit too much. Okay, all I can have in my mind now is let's do the time warp again. Okay, it really drives you insane. It was such a unique and interesting choice of wording by Sergeant Buchanan. Appears to be abdominal thrusts. How embarrassing. Imagine being caught abdominal thrusting with your bros on camera. How would you ever show your face again? Alyssa Ramirez, Higgins plead fifth last trial, right? Chances he pleads again, and will they be able to call if he does? No, he did not. He did not plead the fifth in the last trial. Nobody pleaded the fifth in the last trial. So he testified, and his testimony was he went back to the Canton Police Department. He claimed he was there around 12:30. He was only at the Albert House a short period of time because they didn't have Jamesons at the house, and he doesn't like beer. He didn't want to drink beer, so he left. His explanation at trial was that he had to move ATF vehicles that are just, there in the parking lot. And he needed to move them so that the plow would be able to get through. That was different from previous explanation that he had given, I think during his interview, maybe during the grand jury testimony, that he had gone back to do some administrative work, some paperwork or something. But he's only inside for like 5 minutes on that hallway video. So very quick paperwork if that's the explanation. Anyway, that's what we heard from Higgins last time. So no, he did not plead the fifth. Chances he pleads this time? I don't know, guys. This has kind of come up also with Proctor, and can he plead the fifth if he wants to? My read on it is yes, he can. When I was first thinking through this, I'm thinking, well, did he waive it by testifying at the last trial? He's already answered questions about the subject matter, so surely he's already placed himself in peril. The issue is every time you testify, if you're testifying falsely, it's potentially a new act of perjury. So say you testified falsely last time. Now you're faced with the potential of, well, I can put myself in jeopardy of prosecution, or I can lie again, puts me in jeopardy of perjury. If I have to correct my testimony from last time, it puts me in jeopardy for perjury. So I think he's got an independent right each time they're called to the stand to be able to invoke. The question just becomes, is it a valid invocation? Is the person in jeopardy if they answer the question? Judge is entitled to kind of inquire into that and make that determination. You don't get to plead the fifth just generally as a blanket. I don't feel like answering questions. It does have to legitimately place you in jeopardy. So, as far as does he have a right to do it? Yeah, I think he probably does. It's going to depend on the exact question and exactly how it puts him in jeopardy. But will he? Yeah, I don't know. They didn't last time. And there was a lot of, that was one of the big questions in the first trial. Are they going to plead the fifth? And nobody did. Nobody did. Starry Dust is a new member. Welcome, Starry Dust. No one. TBH makes sense. BH moved the outlying car to group. We didn't see where he moved the car. We see the car back up. It sits there in the middle of the frame for, I don't know, a few seconds, 7 seconds, 10 seconds, maybe. It seems like a decent length of time. And then it pulls around the back out of the frame. We don't see where he parked it. He certainly didn't bring it around and park it right there, like, next to the truck he's getting in and out of, the truck or a big SUV, whatever that was, that's kind of across from his Jeep, nose to nose. I don't know. I have no explanation for any of this. I really don't. My only explanation of it is it's not consistent with what Brian Higgins testified to in the first trial. That's all I can really say about it. And yeah, it looks sus. Getting in and out of all these different vehicles. It looks weird. I would like to have them explain that. Starry Dust is a new member. Welcome. Oh, Starry Dust gifted. Holy cow. Gifted a bunch of memberships. Thank you so much for doing that. Very generous of you. Kim Neighbor, if called to the stand, would you advise Brian Higgins to invoke the fifth? Well, it depends on what I know and what Brian Higgins has previously told me, what he has previously told law enforcement. I don't think I have enough information, from behind the scenes to be able to say one way or the other what the best advice to Brian Higgins would be. Pleading the fifth, you don't generally do that in front of the jury. If you're going to do it, that gets sussed out ahead of time. It's very not preferred to have the fifth be invoked in front of the jury because they draw inferences from it. And in criminal cases, you're really not supposed to do that. In civil cases, it's okay. They'll hold it against you. The fact that you invoke the fifth, they can infer that that means there is something you don't want to talk about. That there is something bad that you need to not be asked questions about. But in a criminal case, they tend to be far more protective of that Fifth Amendment right. So you're really not supposed to draw inferences from it. I don't know. I don't know enough. I don't know what other evidence they have. I don't know what he has told different people in different contexts. It's just hard to say. If he's got an explanation for this video, I mean, I think that's your expectation. He's going to need to explain it. He's going to be confronted with, this is what you said happened at the last trial. This video sure doesn't look like that. Looks like there's a lot of other stuff going on. Do you have an explanation for that? I mean, these people have been very good at coming up with explanations so far. They may not be the most credible explanations, but hey, butt dial, like that. It's an explanation. I forgot about those 3 people that I called in the 10 minutes before the FBI came into my house. I just forgot. He may not have a good explanation, but they may not care. As long as you can come up with some explanation, an explanation. I just don't know. Okay, so now it looks like Ted Daniels is reporting, I've been told testimony in the Karen Reed trial was canceled today due to an illness. So that is starting to be the information that is coalescing. Multiple people seem to be reporting that. Due to an illness, possibly Karen's illness. That makes sense. We'll wait and see if we get any final confirmation. But I am leaning in that is plausible. 5 a.m. research. The Commonwealth is adorable, trying to pull the wool over the eyes of the whole internet universe of sleuths. A lot of sleuths out there. A lot of eyes on the case. A lot of people putting little bits and pieces together. If there's anything to be found, yeah, I expect it could be found. Does seem like possibly some of the sleuthing may have flowed back towards the defense to follow up on, not necessarily, the other direction. Defense gets new things that then gets fed out to the press or the, internet reporters or anything like that. Not seeing a lot of leaking. Not seeing a lot of for example, just information about what the defense might be doing next, who might they be calling, what their plan might be, what their strategy might be. So not seeing a lot of information flow the other way, but possibly some hints that the defense might be picking up on some of the information that the sleuths have identified and figured out. Some of the inconsistencies when we look at the health data, we look at the phone data, we look at the videos, et cetera, et cetera. Scorpid Black Dragon, new vid aids defendant to cast reasonable doubt, right? Well, so at this point in the context of where the case is right now, what do they see? They see what they believe and understand to be Brian Higgins going back to Canton Police Department at 1:30 in the morning, getting in and out of cars, possibly having a bag, having a phone, etc. They don't necessarily have context for why this is significant yet, or, if it is, what about it is significant. They don't know about Higgins's prior testimony. So they don't know what he said and what his previous explanation was, his previous time frame. That hasn't come out yet. The inconsistency, that's potential reasonable doubt. If that does get elicited and spelled out for the jury, this is the explanation you gave. That explanation doesn't comport with what we can see on this video. Timestamp alone, the time is off. You were an hour off. And you were very specific about leaving the Alberts house early because they didn't have Jameson's. He was very specific about that. But that doesn't seem to be the case, does it? It's an hour later than he put himself at Canton Police Department. We see the one car move, but we don't see multiple cars move. And also, there's all these other cars in the parking lot. Why would you just be moving yours for the plow? Those are right where the plow is supposed to need to go. Those cars are all still there. Why the rush? And then why are you getting in and out of the cars? What's all that about? Could be built up into reasonable doubt. Sure. Definitely see it. Joe Drum, he is looking for the luminol and black light. Maybe. Looking for a Faraday bag. Looking to stash a murder weapon. I mean, all these things are possible. We don't know. Are they going to confess if that's what's going on? I kind of doubt it. That would be inconsistent with the course of conduct so far. So if he's asked to explain this video, my guess he's going to come up with some kind of explanation. Oh, I left my gym bag in the car. Need to get my gym bag just in case. Something like that. Like, we believe this guy goes to the gym. Look at him. Not to be rude, but maybe he wouldn't have that hip adductor and bad posture problem if he went to the gym a little bit more. Gotta work that posterior chain, dude. Yeah, I don't know. And so that's the question is, can the jury infer this? Can the jury think this is a possible explanation for what's going on in this video? Is it possibly more plausible than whatever explanation were given by Brian Higgins? If so, that's reasonable doubt. If so, yeah, I definitely see an argument that that's reasonable doubt. Jay Coop, Karen has MS and Crohn's disease. Good sources report she's sick. Prayers go out to her. She has been very ill. Yeah, she does have MS, very serious condition, potentially exacerbated by stress. And trial is a very stressful process. So I hope that she's okay. Nobody wants anybody to have to suffer unnecessarily from illness or something like that. For all that people like karma, people like seeing karma. I don't think anybody wishes unnecessary ill and suffering on anybody in this case. Canton's trout face affliction. Is there a trout face affliction in Canton? Well, enjoy a day off, Andrea. Happy Free Tuesday. Yeah, I guess we get a day off. Just hang out a little bit and see if we get any more information, but not holding up hope that anything is going to happen now. Mark E., do you think the slip of the tongue about the previous trial will affect anything? Do you think the jury will bring it up in deliberations? There have been multiple slips of the tongue now. I mean, I think the cat is out of the bag. At least 3 times, I think we've heard now somebody has said the previous trial. So I don't know if it will come up in deliberations. It hasn't been stricken, so it could. They're allowed to. They haven't been instructed, disregard that comment. When they're instructed to disregard it, they're not supposed to bring it up in deliberations. That's part of the instructions that they get at closing as well. If you've been told to disregard something, then you may not consider it as part of your deliberations. But they weren't told to disregard any of the slips about the previous trial. They've just kind of let it slide and don't repeat it. Don't highlight it, maybe. That can be the problem sometimes if you give a curative instruction. It's like, oh, hey, this is special. Pay attention to this. Like, the whole point is you don't want to paying attention to it. So sometimes you don't have a curative instruction. Just hope that it slid past and nobody noticed. They can bring it up. What do you think about the fact there was a previous trial? They didn't convict her? I don't know. Story Dust. Sorry if you answered this already, but what did BH lie about re the Canton PD visit? The time is the most significant one. He lied about the time frame, and he provided a very specific explanation for why he claimed to be there at, 12:30, 12:45, very early in the evening compared to when he is in fact there closer to 1:30. They didn't have Jamesons in the house, and that's all he drinks. He doesn't like beer. So you had to think that up. The time frame is off is the main one. But also his explanation, he was there to move cars for the plow. We see one car moved. We see, him getting in and out of other vehicles that he's not moving. He doesn't move those two trucks, the one right next to him and right across from him. He doesn't move those, but he has access to them. Or those ATF vehicles? You didn't move them. Do they not need to plow there? But then why'd you move the car? That's the problem. Those are the two big problems with it. Dejan Lujic, no questions, just getting through the day with your stream. Well, it's going to be a short day, I'm afraid. Thanks for joining us this morning. We'll at least get through the morning. Hey, I'm up early anyway, so why not wait and see if we can get a little clarity on what the situation is. Starry Dust, follow up to Brian Higgins lying. Should MSP investigate him? Well, didn't Yuri just say, if there's new evidence, we'd consider it up to this day? We'd consider new evidence. Great. So I'm sure you've gone back and re-interviewed Brian Higgins then, because his testimony in the first trial doesn't add up with what we see on this video. And I'm sure you've asked him to explain that already, haven't you? Of course not, because he's already ruled out. They ignore and rule out anything that doesn't support Karen is guilty. So of course they should, but they, should have done it. Should have done that a long time ago. They should have done that when, they see that this video existed, that they see that there's, potential motive there. Looks like things are heating up tension-wise. He's been ghosted. Nothing. The behavior on the video, and then that eager text to John, you coming here, question mark, question mark, question mark. What does all that mean? They should have asked that question a long time ago. This is some of the last known contact with John. Yeah, you should be interested in it. But they didn't, because that didn't help them pin it on the girl and make sure that, the homeowner knows shit going on him, because he's a Boston cop. Marianne, Yuri Buchanan stated that he didn't think Brian Higgins had a jealousy motive to confront John, yet BH texts John, where are you at 12:20 a.m. and are you coming here? Yeah, exactly. Very eager for John to be in that house. Alan Jackson pointed out yesterday, he was the first one to get there. He's in a hurry to get to Brian Albert's house. First one to get there. And that was the testimony from the first trial. He, remember he testified, he, had his plow, so he went and cleared the row, I guess, in the driveway, and then backed out and parked on the street. They got a whole story about Higgins's Jeep being parked by the mailbox, and it doesn't add up with Ryan Nagel and Ricky D'Antano and Heather Maxson and their story. They never report seeing a Jeep. It's not clear that a Jeep would fit where they're describing all this stuff happening. Ricky D'Antano and Heather Maxson and Ryan Nagel parked behind the driveway, so they would be behind the Jeep, right? Karen would be on the other side of the Jeep. They wouldn't have that view, but none of that is clear in their testimony. So there's something going on with Higgins, the white Jeep, the explanation, the car, where is it? I don't know how to reconcile all this. I really don't know what it all means. But yeah, I think anybody can understand a jealousy motive. Thought you were getting somewhere with the girl. She ghosted you. Well, she's ignoring you. You're pissed. You coming here? He's so eager to get there. I just think that positions like that, the jury is going to have their own opinion about the significance of those texts. And so if the jury doesn't agree with you, then you've kind of made yourself unreasonable, and it's going to be hard for them to trust your judgment about other aspects of the case too. Debbie W. with the Glove song titles yesterday. Did Glove Shack come up? B-52s? I didn't see Glove Shack, but that's a good one. That's a good one. No, I had, glove hurts. Glove is just a lie made to, I don't know, look blue, look like there's something blue on your hand that is being responsible with evidence. Glove Shack, good one, good one. Yellow Pill NP, how sick does someone have to be to miss court? Would a Crohn's flare-up be enough, or does it need to be at the level of going to the hospital? I mean, it depends. I don't know that it necessarily has to be at the level of going to the hospital, but if it's a situation where like you wouldn't be able to sit there in court, you might, need to leave the room a lot or something like that. It would be disruptive. Yeah, that could be enough. It's ultimately kind of up to the judge. So if the defendant doesn't show up to court, it is possible sometimes that the trial can proceed without them, proceed in absentia. And the basis for that is that the defendant has essentially chosen to waive their right to be present. Defendant has a right to be present at all critical stages of a criminal prosecution. Trial is unquestionably a critical stage, but they can waive that right. And so there's often an inquiry if the defendant doesn't show up. Is that a voluntary decision to waive the right to be present, or is this involuntary? Is this something that they can't help? It's unavoidable. If, for example, somebody came and arrested you and threw you in jail on some other matter, and that's why you can't be at court, that's not your choice. So that could create a whole different set of implications as far as what has to happen with the trial. Because if it's not your choice, you're not voluntarily waiving anything. Constitutional rights, if you're going to waive them, a waiver has to be knowing, intelligent, and voluntary. Voluntary being the key word in this context. So if you get arrested and thrown into jail on something else, that's not voluntary by you. That is somebody else acting on you. That's not necessarily going to be a waiver of your right to be present. So they may not be able to proceed without you in that context. With illness is where it can get a little bit more flexible. Is this a choice not to be there, or is this something you can't control? So a lot of that, again, it's going to be in the discretion of the judge. It's going to depend on the information that's presented. Going to the hospital certainly gives you, a better case that, look, I'm so sick. This is not my choice to just not come. But it's not required. It can be up to the judge. So possible that there were communications with the court to let them know, hey, she's sick. What do you want us to do? And as long as there's no issue, no concern that, well, the judge might find that she's waiving her right to be present if she's not there, then we don't have to go to court and argue about it. We don't have to try to get Karen there. We don't have to take her to the hospital. Court will take her word for it. So, some of that is discretionary, but given that we haven't heard any indication that they were considering proceeding without her, assuming that it is her that is sick, which does make sense. I mean, it's possible it could be one of the other players as well, Brennan maybe, but if he was there in court and seen there in court, then probably not him. Since they're not talking about proceeding without her, they're just accepting if she is sick that it's not a choice whether or not she had to go to the hospital. Dawn on me, Higgins had a lawyer at first trial. I think we thought that. Was that confirmed that he had his lawyer sitting in during the testimony while he was present? I don't remember if that was confirmed, but there was somebody else there. Did they do was there now I'm kind of remembering, was there a sidebar or something done outside of the presence of the jury? I thought that was Brian Albert. where there was like a question, is somebody going to plead the fifth? Yeah, I have vague memory of this, but unfortunately just don't remember super clearly. He may have. He may have. Happy HK is a YouTube member. Welcome to the channel. Thanks for joining us. Jason Smith, Andrea, he was accessing a flip up door in that truck cap and grabbed whatever it was out of there. If you zoom up, you can see him do it. Yeah, I was trying to watch, like, what is he doing over here by this truck? It's so unclear. It's way over by the edge of the video. The lighting's bad. The snow is coming down. It almost looks like he's trying to clear away the snow. It looks like it's, dark for a minute, but then it's light again and the snow is back. Is that a flip up door? Because then it does seem like there's a bag out of nowhere. So, and it does look like a bag. Looks like he's got a duffel bag. Plausible explanation? I mean, could be. It's just hard to know how much weight to put on the video. It really is. How much is showing us that, can't really trust our own eyes. Carolyn Smith, I wish AJ had made it clear that B. Buchanan lied about the Sally Port video last trial. New watcher, and I wouldn't have caught it. Yeah, I mean, he brought it out, but it really didn't get hammered home. That the problem with the Sally Port video wasn't inherently the fact that it was inverted. I mean, that's not ideal. It's certainly not ideal. But it's the fact that through the entire direct examination, Buchanan didn't identify that this video was mirrored, and he was asked to narrate it. What are we seeing? Proctor, nobody goes anywhere near the right rear tail light. But that only works with what you can see with your own eyes if that video is not mirrored. It was a deceptive account of what the video is showing. And so I'm not sure that really got hammered home. The fact that it only was elicited that this video was mirrored only on cross. He didn't bring that up in any of his direct. I'm not 100% sure that was real clear either. KKD 87. Cloud on Yuri giving his medical opinion on John O'Keefe's body. Oh yeah, force to cause his head injury. No, you don't get to say that. He tried it last trial too, didn't he? He was they tried to get him to be able to testify that John's eyes were consistent with he's seen brain injuries in the past, and that it was consistent with swelling from a brain injury. Didn't allow it last trial either, but sure did try again this trial. Trying to get those medical opinions from Sergeant Buchanan. It shouldn't be allowed. It's not appropriate. Nasir Puto, you need an ASMR lawyer channel reading the Constitution and Founding Fathers texts, Supreme Court texts. Your voice would make a fortune. Well, thank you for that. Do people really want to doze off and relax to the dulcet tones of Article 3, Section 8? Is that what the world needs right now? I don't know. The Federalist Papers? Is that what we need? ASMR Federalist Papers? Well, if I get some abundant free time, maybe I'll give it a try. See if it takes off. Thanks for the suggestion. WM Penguin, why would they stipulate to the authenticity of the video despite it blatantly being manipulated in some way? Could that cause problems on appeal? The only problem it causes on appeal is that they've waived any challenge to the authenticity of the video. So I don't think they get to go forward on appeal raising any sort of argument about the metadata issues, for example, the back and forth that they had with the litigation trying to get the forensically sound copy of the Sally Port video. That's waived now. because you can't show that there was any harmfulness in what they did if you're acknowledging that this copy that you have is authentic. So, I mean, I think it's raised issues that way. Thinking a little bit further down the road, so hypothetically, let's say hypothetically Karen gets convicted, hypothetically she appeals, and it's affirmed on appeal. Then we're looking at a post-conviction process, a habeas type of process. Unlike appeal, habeas processes are where you can typically bring in new evidence. You cannot on appeal. Appeal is just looking at the record of what happened and saying, is there a mistake here? Was there an erroneous legal ruling that affected the outcome of the trial? So if it's not an erroneous legal ruling because it didn't come up, it's new evidence or whatever, you don't get to deal with it on appeal. You have to deal with it in habeas. So let's say we get to habeas and now they have new information. Maybe they have somebody post-conviction has gone through and they have analyzed the video and they've got an expert who's looked at it and they've identified, here's indications that the video was altered. Can they raise it then? Potentially, but they still have to deal with this stipulation. And probably the way they deal with the stipulation is by arguing it's ineffective assistance to stipulate. If you hadn't investigated, if you hadn't gotten the information that you needed to be able to say definitively one way or the other, this is authentic or not authentic, then perhaps an argument that it's ineffective to stipulate. So that's kind of the only way I can foresee this arising down the road in that kind of process. So why would they do it? Well, because they wanted to use it. They needed to use the video. That was the condition that Hank put on not objecting to it. Could they have gotten it in without his objection? Probably. Might be a little trickier to lay the foundation with Yuri Buchanan being an uncooperative witness, but he did authenticate this stuff in the last trial. So you could have probably gotten it in over an objection. But all we know is that the defense does not intend to pursue an argument that it was altered. They have given that up. That is very clear at this point. Why did they do that? I don't know. Strategic, probably, but maybe not. Don't foresee any problems with it on appeal. If it comes up in post-conviction, it would probably have to be in an ineffective assistance context, saying that that stipulation should not have been made because there was insufficient investigation into whether it was authentic or not. Lousy David, Crohn's patient here. Oh, very sorry to hear that. My flare-ups rarely land me in the hospital, but I'm usually bedbound for at least 18 hours. This sounds like an absolutely miserable condition. It really does. No fun at all. So, yeah. Appreciate you sharing that with us, giving us a little bit of insight into if that is going on, what that might be like. The Wirtz BH attorney was up by him. So I guess in the first trial, yeah. You guys might remember that more clearly than I do. I just have vague memory of there being an attorney, but I can't remember the context real specifically. Zoe, it was a voir dire on improper use of government resources, and Higgins' attorney was up next to him, if I remember correctly. That's right. Thank you for that reminder. That's what it was, because the issue involved whether he was going to plead the fifth over the line of questioning about him accessing the extraction tool. He described it as like a station that he went there with his friend who was FBI guy let him in to be able to do this. So he's able to extract his own phone selectively just for what he wants. So that means he's not doing a full file extraction like you hear about with Celebrate. What's the most common and preferred thing forensically to do, for law enforcement to do. He went in and selectively identified what he was going to extract from his phone and then extracted only that. But yes, that's right. I forgot about that because the argument was he's implicating himself in the crime of improperly using FBI resources. And so is that something he's going to take the fifth on or not? The attorney was there. Thank you. That does refresh my recollection. I remember that now. I remember that sidebar. Mickey P. Jen had John O'Keefe's phone, returned to 34 Fairview, and hid that until FBI data. Did she take pieces in AM after saw cracked, deleted Ring video planted before search? Here's the issue I have with trying to put the phone in Jen McCabe's hand, and that is that the cleared, the pocket state. The pocket state activity is the first thing that the phone does after this long period of it doing nothing at all. It taking those steps, the lock button is pushed, and that's it. It searches for the pocket state periodically throughout this process, but it logs cleared at 6:02. Pocket state cleared at 6:02. And I think that might be before they got there. I think that might be before they got there. We know from the 911 call and the voicemail that got picked up on John's phone because Karen was calling John from the back seat of Carrie's car. The phone apparently answers like right as they are getting there because the phone just gets dropped or left unattended with the call still open. And so it goes to John's voicemail. And then, we heard that voicemail. It was the last one that Hank Brennan played from John's phone. And it has the 911 call and that, activity going on in the meantime. So, and that was 6:03. That's like 6:03-ish. So I am not 100% sure. I'm not 100% sure that time frame coincides. I just don't know. I don't know. Did she take pieces in the AM after she saw cracked, deleted Ring vid planted before search? Tracking the phone would sure help us figure that out, wouldn't it? I don't think she deleted the Ring video because we heard from the last trial there is a sticky note. There's a note from Trooper DeChico where he identifies, but maybe that was the time Karen returned home from 34 Fairview. Maybe that wasn't the time when all of these guys left. I just don't know. Let's say this. Can we say, based on the information presented at trial so far, that this theory is impossible? I don't think we can. I don't think we can definitively rule this out. It would be potentially a tight time frame with the phone. Access to the video. Yeah, I don't know, guys. I don't know. I don't know that we can say we can rule this out. Z, Higgins's lawyer said only need 10 seconds to speak to his client, which contradicted Higgins' testimony that 22 seconds butt dial can't be a substantive conversation. Yes. Yes. Very good memory. Totally refreshes me on that. They did that offer of proof and then yes, he said, well, we'll need 10 seconds to confer. And then, Higgins did not invoke the fifth. And they had previously heard, there's this 22 second, but you couldn't say anything. You couldn't say anything meaningful in 22 seconds. So the fact that they could have a whole private attorney-client consultation in half of that time did tend to indicate that 22 seconds might be enough to communicate some critical information if you guys both know what you're talking about and what's the subject matter and what your interests are and all that. You can probably say a lot in 22 seconds. Z, why didn't Bev allow headset for Karen due to health? May not have been requested. I mean, again, she has a right to be present If she can't be present for circumstances beyond her own control, she doesn't get to be penalized for that. So if she is truly sick, she is not choosing not to be there, and she does have a right to be there. So a headset is not really going to be, equivalent. It's really not going to be equivalent. Now, Zoom Court gave us a whole kind of different set of standards during COVID, because this came up a lot. This competition of the right to be present, the right to confront people. How do all of these rights play out when we're all videoing into court and nobody is actually in the same room at the same time? I don't recall ever seeing a decision come down where they said Zoom court was not adequate to be present, as long as there was there needs to be an opportunity for if it's the defendant, who's zooming in, they need to have an opportunity to be able to confidentially confer with their attorney about what is happening in court. Being able to have that conversation, not be picked up on Zoom, not, broadcast to everybody. So there needs to be like a waiting room or another line or something like that, some way for them to be able to step out and confer. Because normally in the courtroom, you're at the table, you can write notes to each other, you can whisper back and forth. You often need to do that during an evidentiary stage because, the defendant has knowledge that the lawyers don't. So you often need to communicate about stuff like that. And then just otherwise, that making sure that the Zoom process, the setup is adequate to be able to see the exhibits, see the demeanor of the person who's testifying, and so forth. The sound is good. If you have a terrible system with bad sound, might affect the constitutional right to be present for trial. So could she Zoom in? Maybe. But I don't know. They're not requiring it. Just don't know anything else about the very specifics of the situation. So it does look like there might be a new, let me pull this up here. Well, let's see. Breaking: Judge Cannoni is holding a Zoom hearing with attorneys for Karen Reed. Prosecutors are in the courtroom. Attorneys Yannetti and Jackson are appearing remotely. The judge wants this at sidebar. I'm the only reporter in the courtroom. Then the judge just decided to close the courtroom, and I was asked to leave, probably due to issues with the Reed defense team hearing what was said at sidebar. Closing the courtroom is a big step. Big step. I don't know what any of this means, guys. I don't know what any of this means. This is consistent with what Turtle Boy was saying, that there were going to be that there were rumors that there was going to be some kind of sidebar, some kind of zoom in with the judges, with the attorneys. So Yannetti and Jackson are remote. Obviously not there. Going to close the courtroom. That better be confidential stuff then that they're talking about. Better be confidential stuff. It's the same kind of standard for when they're going to sidebar to communicate about things. It really should just be the confidential stuff. The rest of the time, we have a right to know what's going on in court, and the public has a right to attend court. So closing the courtroom is a big step. They better be dealing with something confidential. I don't know what that is. Love to be able to shed light on this, guys, but I just, I have no idea. Why can Karen not zoom in? Maybe it's, worse than we think. Maybe it's not just, she's feeling a little under the weather. Could be very serious, and she isn't able to focus or attend. I don't know. Charlotte ASMR, Andrea here for the company during lack of trial day off. Sorry, off topic, but thoughts recent BK, Idaho updates, Dateline, etc. Thank you. Well, guys, I didn't watch the Dateline. I've seen commentary about it, bits and pieces about what's out there. Here's the problem. Here's the problem that we have with this case. We know that misinformation and disinformation, they've already been replete with the media in this case. So it's very difficult to trust what's out there. We had to have a whole hearing, where they're specifically telling us during that argument on the change of venue, a lot of this information that the media is running with, it's false. It's false. It's not true. So that is possible. We don't know. Here's what we do know, though. You got one of two choices. It's false, what Dateline is running with, or it's not. If it's not, is somebody violating the gag order to give them that information? Oh, you better believe it. You better believe that's a violation of the gag order. Makes it very clear. Prosecutor and its agents, including law enforcement, not allowed to make extrajudicial comments about the case, information about evidence, anything like that. You better believe it would be a violation of the gag order. So what I am curious to see is what, if anything, is done about that. How seriously does this court take its gag order? Is it going to do anything to try to find out if this information is true? Who leaked it to Dateline? They have the ability to do that in Idaho that they don't have the ability to do in many other states because Idaho has no reporter's shield law. Reporters have no protection against revealing their sources in Idaho. So hypothetically, we get to trial, Dateline shows up. Yeah, if the judge really wanted to and was really interested in the integrity of its order and maintaining that and enforcing it and sussing out who is flagrantly violating it, yeah, you could compel that Dateline person to give up that information. And if they don't, they're in contempt. And somebody at Dateline can have a Susan McDougal moment if they want it. I think this is a come to Jesus moment for the court. Is this order for real? You okay? You okay with just being ignored like that? Or are you going to do something about it? This order that is ostensibly necessary to protect the integrity of the process? Yeah, so when that gets violated, you going to do something about it or not? That's what I'm interested in. That's what I'm interested in seeing. I don't know if it's true or not because there's been so much false information. And so until we get into court and see what is presented, we don't know if it's true or not true. We don't know. I'm going to wait and see what comes out at court at this point. It's not in any of the pleadings. Some of it seems inconsistent with information that we've received before. So I'm in wait and see mode when it comes to this case because we haven't been able to trust what's in the media. Told us specifically, not just one side either, both sides, prosecution, also confirming a lot of this information is false. Like what, for example? Stalking. Stalking in particular, evidence that he stalked any of the victims or the King Road? False. They told us that in the court hearing. So, don't know what to make of it until we get to trial. But if there is any validity to it, I'm going to be very interested in seeing how seriously does the court take its own order. The court may be going to do something to enforce that. Looks like we've got a couple more follow-ups here from Mr. Hall, after the judge decided to close the courtroom, hearing has been going on for 10 minutes now. Jackson originally appeared off camera because he's dressed in a hoodie. Judge said she didn't care and he turned his laptop camera on. Hearing is over. No comment from Brennan. So maybe Jackson's the one that's sick? Don't know. Don't know. Don't know what to make of any of this, guys. Don't know what to make of any of it. I buy that somebody is sick and that's why we're not having court today, but who, what, why, I just don't know. No idea. Anyway, thank you for your question. It is a little off topic, but that's okay. We're just waiting to see if we find out more about what's going on in the courtroom. So we can catch up on Koberger. It's gotta wait and see. I have no idea if it's legitimate, and if it is legitimate, the court should be alarmed. And I would think the court would want to do something about that, because otherwise you're just signaling your orders are meaningless. People can flout them at will. Not a good look. Not a good look. Issuing orders you don't intend to enforce. Lucy Fair, Hank not being involved in trial 1 is a benefit to the Commonwealth, in my opinion. AJ may take knowledge for granted, hence not emphasizing certain things to the jury. This is a big risk of trial work in general. You do so much prep, you get so familiar with the case, you know all of the ins and outs of it so well, and it gets difficult to put yourself in the shoes of somebody who doesn't know any of it. You just lose perspective on what it's like to see it all with fresh eyes and to have perspective on what needs to be emphasized and what didn't. So yeah, I mean, AJ's already gone through this trial once. And so to the extent that that's kind of already part of his muscle memory, so to speak, might be easier for him to lose sight of what this particular jury has already heard and what they know and what their basis of knowledge is and all of that. Brennan being fresher to it may not have may not have that same kind of difficulty, or the difficulty to the same extent. So possible. It is very difficult to have that fresh eyes perspective. Sentient Dreamer, while I miss court, this Q&A is really nice. Well, I'm glad. I'm glad you're enjoying it. Glad you're enjoying it. That is all that we have for now, right now, guys. I did want to go ahead and pull up. We're going to go ahead and, we're going to still take a little bit of time to see if court is going to come back. But in the meantime, we do have another pleading that we get to look at. Christina Rex has gotten a hold of the defense's response to that motion about limiting their ability to present evidence under the guise of the Bowden defense. So I will go ahead and pull that up, and we can take a look at that while we wait. So that should be big enough to see. Defense's opposition to the Commonwealth's motion to preclude inadmissible hearsay under the guise of a Bowden defense. So this sort of, at least maybe partially got dealt with yesterday. They did have that little bit of a voir dire about what does Sergeant Buchanan know with respect to the investigation, and particularly the text that Michael Proctor was having with other people that Sergeant Buchanan was not a part of. So the text with Courtney Proctor and the text with his friends on the night of the 29th, where he said all the things about, bad stuff about Karen and her medical conditions. And then nothing's going to come on the homeowner. He's a Boston cop too. Didn't get to ask about any of that because it's not something Yuri has personal knowledge of. And so if he's going to deny being aware of it, there's no way for that to get him in. So They got kind of a partial win, at least on that. But because that motion was very vague and unspecific, it wasn't, addressing any particular piece of evidence. I don't know if that's resolving all of it or if this is still outstanding and there's more to talk about. So this got filed yesterday at 9:00. Could be that this is a dead issue and it's already been dealt with, but it also could be that this is something that may recur perhaps with other witnesses, other law enforcement that might get asked about what they know. I don't know. I mean, I don't know what the Commonwealth's case is going to be. I don't know who the defense is going to call, how all this might flesh out. So we'll take a look and see how the defense has opposed it. So now comes the defendant, Karen Reed, Ms. Reed, and files the instant opposition to the Commonwealth's motion to preclude inadmissible hearsay under the guise of a Bowdoin defense. The Commonwealth seeks to undermine Ms. Reed's right to confront her accusers and to cross-examine witnesses, a right conferred by both the Sixth Amendment of the United States Constitution and Article 12 of the Massachusetts Declaration of Rights. Massachusetts Rule of Evidence 611b1 gives the right practical effect, allowing questions on cross-examination on, quote, any matter relevant to any issue in the case, including credibility and matters not elicited during direct examination. Goodness, that was a loud yawn by the dog. Don't know if you guys heard that. The only requirement is that questions are asked on a, quote, reasonable and good faith basis, unquote, regardless of whether the party intends to offer substantive evidence of the statements at trial. So you can't just make stuff up and ask them about it. Do you, I don't know. I'm not going to make something up on the fly, I guess. You don't get to make things up and ask them if they knew that or if that's, something that they investigated. Like, you can only ask about things, even if you can't prove it. Maybe you've received information, there's been gossip or something like that. You want to ask about it. That's your basis. You have some information, but you may not have information that is in admissible form that you'd be able to present at trial. So questions do not need to be based on admissible evidence, though they may be curtailed when a witness makes continual and repeated denials. Other limits to the scope of cross-examination are harassment, prejudice, confusion of the issues, the witness's safety, or interrogation that is repetitive or only marginally relevant. Vague suggestions of racial, ethnic, or religious prejudices without any support are impermissible. Limits, however, do not include instances where the defense seeks to elicit testimony from a witness about the adequacy of police investigation. Such testimony is explicitly protected under Commonwealth v. Bowdoin and Massachusetts Rule of Evidence 1107A as both relevant and permissible. So they're kind of generally just setting out the standard of what you get to ask questions about. I'm not sure that this applies. Like, I don't know that there's any implication that they might ask about racial, ethnic, or religious prejudice. There's definitely questions about bias, but that's going to law enforcement bias, their prejudgment, their expectations about who is a suspect and who isn't, and therefore the actions they took based on that. But that's not based on protected class stuff like racial, ethnic, or religious preferences. So just generally stating the rule, not totally sure that that's relevant, but bottom line is getting to cross-examine about the adequacy of the police investigation is protected by case law and the evidence rule. So testimony elicited in support of Ms. Reed's Bowdoin defense does not have the effect of harassing the witness or confusing the jury, nor are the questions, quote, marginally relevant, unquote. Rather, questions on cross-examination about an investigator's knowledge of the very investigation he was conducting is highly relevant. So here we have the first point, and I think this was an important one, and this comports with kind of how I understood this issue to be panning out in court while we were watching it unfold. The testimony Ms. Reed seeks to elicit in support of a Bowdoin defense is inherently not hearsay and is admissible. They weren't using it for a hearsay purpose. They're not bringing up what Proctor texted in the group chat because they want to prove that David Yannetti's client is retarded. Okay. It's not offered for the truth of the matter asserted. It's offered to prove the information that they had that was available to them. And so, how did that affect their state of mind, their basis of knowledge, and what did they do based on that? Whether the information was true or not, what did you do with it? So, it's not offered for a hearsay purpose. I think this is the very first point that they're making. Defendants have the right to base their defense on the failure of police adequately to investigate a murder in order to raise the issue of reasonable doubt as to the defendant's guilt in the minds of the jury. Specifically, Ms. Reed is permitted to offer evidence, quote, regarding a third-party culprit whose existence was known to the police, but whose potential involvement was never investigated. That is squarely from, Bowden and its progeny. In this scenario, the risk of prejudice to the Commonwealth is less because the police are able to explain what they did to determine the suspect was not guilty of the crime. So they get to explain, how did you rule out Brian Higgins? How did you decide that Proctor saying these things didn't affect his credibility, his integrity as an investigator? Whether there are other potential suspects with incentive to direct police attention away from themselves and towards someone else, namely the defendant, is highly relevant in a criminal trial. Citing a case with the parenthetical, finding it improper to prevent a defendant from cross-examining police officers about their knowledge of the criminal records of other potential suspects. You get to ask, do other people have a reason to divert attention? Do they have a motive to cover up, provide false information to police, et cetera, et cetera? Evidence offered in support of a Bowden defense is not hearsay testimony. It is not offered for its truth. Exactly. It's what did you do with the information provided to you? Another parenthetical, because any statements introduced as part of such a defense are offered not for their truth, but to prove that the police did not take reasonable steps to investigate, those statements are not hearsay. And then Reynolds, the Commonwealth's assertion that the evidence properly was excluded because it constituted inadmissible totem pole hearsay misses the mark. The defendant did not offer the substance of the informant's tips for the truth of the matter asserted. Yeah, police get a tip from the informant. What do you do with it? That's all that matters. Not is the tip true or not. Did you do anything with this information? If you just ignored it and took no steps to rule it out, that goes to the Bowden defense. Because it suggests the police investigation was biased. They were not following the evidence. Otherwise, you would have followed up on this tip, and if it could be ruled out, then you would rule it out. Just because the same testimony, if offered for its truth, would be inadmissible hearsay, does not mean that it must be excluded. Evidence can be offered for many different purposes. That's kind of part of the fundamental difficulty that you often have with the hearsay rule. Guys, you spend like half a semester on just the hearsay rule in evidence class in law school. It gets pretty complicated. And yeah, because evidence can be offered for a lot of different purposes. And so how it gets treated depends on exactly what purpose you're using it for. The fact that it could be used for other reasons doesn't mean that that's what you're actually using it for. And so that can affect whether it's admissible or not. In fact, various cases recognize instances where testimony may be offered for purposes of a Bowden defense, but not for a third-party culprit defense. And they've cited some cases for that. By definition, questions about Buchanan's investigative knowledge are not hearsay. The testimony elicited from these questions go to his knowledge, understanding of the investigation as it was unfolding, not to its inherent truth. I think that is exactly the point. It's what did he know and what did he do based on that knowledge? The Commonwealth's motion recognizes that questions about an investigator's knowledge under a Bowdoin defense are not hearsay. However, proceeds to suggest that answers to questions to this effect are inadmissible hearsay. The Commonwealth's motion goes on to accuse the defense of asking repeated improper and argumentative questions, and yet does not offer one example of such questions. Were the Commonwealth's motion granted, it would effectively gut Ms. Reed's ability to offer a Bowdoin defense by erroneously classifying the very questions and testimony that compose a Bowdoin defense as hearsay. The lack of specifics in the Commonwealth's motions, this has been kind of an ongoing issue, something that I've noticed before. They make these kind of general claims and general statements and ask for sort of broad relief. But so much of the law is it depends. It really depends on the specifics. It really depends on the details. And so not identifying specifically, what do you not want them to ask? It poses a little bit of a problem in terms of being able to grant some kind of relief, because it's rare that a whole broad general principle like this is going to apply. It depends on what specific facts you're trying to apply the rule to. That's kind of how law works in general. The Commonwealth is correct that it must be reasonable to expect that police should have followed certain procedures or investigated such information to be admissible. The Commonwealth fails, however, to explain precisely what is unreasonable about the defense raising alternate suspects that state police chose not to investigate, despite being aware of their potential motives and opportunities to commit the crime Ms. Reed is accused of. The Commonwealth states that the defense's questions thus far have been improper, and yet provides not one example of such improper testimony. Again, the lack of specificity. If you want to complain about what the defense is doing, you're being argumentative by just kind of characterizing what they're doing in this way. If you provide an example, that puts some meat on the bones of what you're trying to argue. And then we can see, okay, they did that. It was improper. It was proper. Don't do more of that. But then we can identify exactly what it is about that makes it a problem. And then everybody's on the same page about, where the boundaries are. Here's the strike zone. You got to keep it in here. Some judges will let you go, let you go up in the high outside corner. Others won't call that. If you look at it and you can identify something specific and tell us why it's a problem, then we can all be on the same page about that. But if you just talk generally, they're being argumentative, that's not helpful. That's being argumentative. It is true that that evidence offered for a Bowdoin defense must be relevant and more probative than unduly prejudicial. Here, the Commonwealth makes the bare suggestion that testimony about Buchanan's knowledge of other potential suspects is irrelevant. However, it is unclear how a key investigator's understanding of the investigation could be anything other than relevant. Further, it is worth noting that all evidence or testimony proffered by one party will be prejudicial to the other. The key question is whether the testimony in question is unfairly prejudicial. This often comes up when you're talking about the balancing test. It's in Rule 403 in Massachusetts, most places. The general rule is evidence is admissible if it's relevant. All relevant evidence is admissible. That's kind of your baseline. Evidence is relevant if it has the tendency to make the existence or non-existence of any fact that is material to the resolution of the case more or less likely. So if it tends to let you find something to be true that matters, or find something to be untrue that matters, then it's relevant. So then the exception is in Rule 403, where you have the balancing test. Notwithstanding this general presumption that all relevant evidence is admissible, it can be excluded if it's prejudicial, if it's probative value, what it's tending to prove or disprove, is substantially outweighed by the potential for prejudice. And prejudice can often be undue delay, harassment, duplication, unnecessary duplication, and stuff like that. substantially outweighed by the danger of unfair prejudice. Not just that it hurts your case. Yeah, anything the other side presents, you should probably assume they're not there to make your case for you. They're there to hurt your case. So their evidence is probably going to hurt your case. The question is whether that's unfair. Is it an unfair inference for some reason? And so where this will often come up is, for example, they do this same type of weighing in the 404B context. 404B is the prior bad acts. We've talked about this before. Say hypothetically, we had evidence of Brian Higgins getting in lots of fights with the boyfriends of girls that he's been texting. You know, he's got a history of this. He's done it like 2 or 3 times before, and we have evidence of it. 404B says, number one, you don't get to admit that evidence just to prove he's got a propensity to do this kind of thing. So you don't get to say he did it before, therefore he probably did it this time. That is not a proper inference that you get to make in a court of law. Might be counterintuitive to people as a matter of common sense. Lots of people think best predictor of a future behavior is past behavior. It is or it isn't. The problem is if people get the idea that you're this kind of person, then even if you are innocent this time, that smear can carry over. And people will convict you on the basis of what you did before, not what the evidence tends to prove you did this time, because it is very powerful, because people do assume that, oh, if you did it before, you probably did it this time, but you might not have. So the guilt or innocence has to be decided on the strength of the evidence of this particular incident. So that's why prior bad acts evidence gets a little bit of special treatment. It creates this very strong inference that isn't necessarily fair. So you have to have a non-propensity reason for using it. Okay, well, let's say it all follows the same MO. It all follows the same MO. He has the same MO of responding to texts in this particular way and giving the girls the ick, and then they ghost him. And then he runs into them at the bar, you know, a couple of weeks later, tries to get their attention, doesn't, calls out the boyfriend, and they fight. They fight at Brian Albert's house even. You know, we'll make it a real specific MO. MO is one of the exceptions, modus operandi. It goes to prove identity in the 404B context. So you might be able to make that case. It's got to be very, very similar, almost like a signature, you know, similar and distinct. But let's say we can meet that. Now we have a non-propensity reason for offering this evidence. So that hurdle's been clear. The next thing we do, though, is then we then go and do this 4043 analysis. Is the probative value of that, of the jury knowing, okay, there's an MO here, he's done this other times, is that substantially outweighed by the risk that the jury is going to be like, oof, he did that before, he did it this time, that they're going to use it improperly? That's what the unfair prejudice is about. Are we going to run the risk of just putting the jury in a position where we can't really expect them to follow the instructions that they're given? This evidence is too powerful. The inference is too strong. They're going to use it. There's a significant risk they're going to use it the wrong way. Comes up in that context. So that's really what you're looking at when you're talking about unfair prejudice. Not just is somebody going to think your case is bad because of this. That's the whole point. I put on my case, you put on a case showing my evidence is bad and yours is good. I put on a rebuttal showing that yours is bad and mine is better. That's just the nature of a trial. But unfair prejudice is there a risk that this evidence is going to be misused or that bad inferences are going to be drawn from it? Here, it is unclear how such testimony would be unfairly prejudicial to the Commonwealth, particularly where the Commonwealth has the opportunity to rebut any testimony on redirect. Harkening back to that parenthetical where they're explaining, the cops can explain their investigative decisions, and if they have a reason why they didn't investigate this, go down that road, they can present that to the jury, and then the jury will decide, was that reasonable or not reasonable? Should they have followed up on that or not? The jury is the ultimate decision maker of all of these factual questions, including, was this a good investigation or not a good investigation? 2, the appropriate avenue for the Commonwealth's concerns is a robust rebuttal. Well, I'm not sure they exercise that remedy with Trooper Buchanan. Myself really was not super impressed with the robustness of that rebuttal. But yeah, this is the argument. That's the way for them to mitigate any prejudice that they perceive. Further, the Commonwealth asserts no basis in its motion for the claim that voir dire is the appropriate way to address their unsupported claims. The Commonwealth cites Commonwealth versus Avila to suggest that the defense is seeking to elicit what it calls inadmissible hearsay and to support its request for a voir dire hearing. However, Avila did not address voir dire issues. Rather, it allows for a robust rebuttal by the Commonwealth of a Bowdoin defense via redirect and the introduction of additional evidence. Further, Avila holds that a curative instruction about the purpose of testimony offered for a Bowdoin defense and in rebuttal was an appropriate avenue to address concerns as to how that testimony would be considered by the jury. We've heard a lot of curative instructions so far, mostly dealing with statements that are made. For example, when we heard Karen's Sergeant Buchanan reported what he says Karen Reed told him during the interview, which for whatever reason was not recorded. Only Lucky Loughran's interview was recorded as far as we know so far. A little bizarre that, but she gave the jury that curative instruction that before you consider any of this, you have to decide, it's more likely than not that she did in fact say these things and that her statement was knowing, intelligent, and voluntary. She wasn't coerced to make these statements or anything like that. That's the rule apparently in Massachusetts. Washington, we don't follow that. The judge makes a preliminary determination about whether it's voluntary. Otherwise, the jury just goes to the weight. You can still go in and argue to the jury the statement's been coerced, but there's no they don't have to make a preliminary finding like this. But whatever, that's the Massachusetts standard. So we've been hearing curative instructions about that. And we've been hearing curative instructions. Statements are not being offered for the truth. So you're not to consider it for the truth of what it says. That's the cure for most of this stuff. Effective cross-examination is a critical safeguard of liberty and an invaluable tool for testing the reliability of evidence. And as the Supreme Judicial Court has long recognized, surprise is an important element of effective cross-examination. Here, the Commonwealth seeks to undermine this important right and vitiate Ms. Reed's constitutional right to cross-examine a key prosecution witness by seeking an order that Sergeant Buchanan be permitted to preview the questions that he will be asked by the defense at a voir dire hearing in advance of his testimony before a jury. This request must be denied. This is a very good point. This is what we called out, I think, yesterday in real time when this was happening. Yeah, this is kind of just like those Daubert-Lanigan motions. It's just an opportunity to flesh out the testimony, get a preview, because you don't have the right to do depositions in Massachusetts. You don't get to do that kind of pretrial discovery. So you find out what they say when they say it at trial. Looked like they just wanted him to be able to see what they were going to ask ahead of time and deal with it. Saw an opportunity to make that request and took it. So in conclusion, Ms. Reed has the right to mount a vigorous defense of the allegations against her. She has a right to confront and cross-examine witnesses, and she may present evidence that police investigation in this case was deficient. Ms. Reed respectfully requests that the court deny the Commonwealth's request to deny her constitutional right to confrontation. So that's their response. What do we make of this in light of what we saw actually play out yesterday? They did do the voir dire at a recess. Basically, they took the opportunity to do the voir dire. My understanding, based on all this, how the judges sorted that out, they did the voir dire to elicit whether the defense had a good faith basis to ask the question. That's what the voir dire was geared towards. Do you have a reason to think that Sergeant Buchanan would be aware of this? So they ask him, are you aware of it? He's not aware of it. Potentially because this is voir dire, maybe could have pushed it a little bit further, pushed back on it a little bit harder. It's your role as a supervisor. You didn't learn about this. You've learned about it since. Is this the very first time you're hearing any of this information? They did kind of, I think, in some of that. They did explore that a little bit. You're saying this is the very first time you're hearing that information? Yes, indeed he is. He is saying that. So I think that's what the voir dire was geared towards exploring. If you're going to ask him, is he aware of this information? You have to have some basis to think he's aware of it, not just that the information exists, but specifically, to the question that you're asking. So that's what I think the voir dire was about. And so looking forward, if they have other investigators on the stand and they want to pursue this same kind of line of reasoning, if, for example, the defense calls Proctor and they want to pursue this same type of avenue, you knew this stuff, you didn't follow up, why not? This is likely to be the kind of framework that we're going to work within. They may have to do a voir dire if they don't know if it's something that he knows, he doesn't have it in a report, it's something that was communicated, to or by other witnesses. Could see more of the same. So that is where I think we're at. That's where I think we're at. Not seeing, just going to check in real quick on nothing new from Ted Daniels. Anything new? Jonathan Hall, of course, had the Zoom hearing, says that that's over. Jonathan Hall does say due to HIPAA, they can't say who's sick and what it might be. No. Where is bad HIPAA takes when you need bad HIPAA takes? HIPAA only applies to medical care providers. The court, the lawyers are not medical care providers. They can share people's private medical information. It does not violate HIPAA. However, it may violate other privacy protections that exist in Massachusetts law by statute or whatever. Very common for this type of stuff to be redacted in a trial, but it is not a HIPAA violation for the court to say what somebody's medical situation is. Does look like, let's see, another reporter stating a closed door hearing has just concluded. Brennan and other prosecutors were present. Reed's defense lawyers appeared via Zoom. Court official confirms testimony was canceled today due to a health issue. Did not specify whose health. No word if court will resume tomorrow. So there we have it, guys. We may or may not be back tomorrow. I guess we'll, be ready and show up and see. But confirmed for now. It looks like not going to be any hearing today. No surprise. Somebody is ill. We don't know who. So with that, guys, I think I'm going to get ready to wrap us up here. Go through the last of your comments and questions. Jessica, thoughts on John O'Keefe Sr. being only on the defense witness list and Aaron Paul, Aaron, kids, etc., only on the Commonwealths? I don't know what information they have. John O'Keefe Sr., the only reason I remember him coming up at all was from the first trial. Now I have to think because, you get confused with what do you remember from what context. Pretty sure we heard it in the first trial. We didn't hear it in this trial about when Karen was in the hospital. Carrie Reed testified to this, that she was with the O'Keefes and they saw Karen, and Karen said she dropped him off at the house. And then Peggy says, you mean you just left him there, being negative. And then John O'Keefe told her, go easy on her. She's had a hard day. It's
all I remember John O'Keefe coming up with, coming up with anything that sort of is known that we know about is based on that prior testimony. So he stood up for Karen in that context. Seemed to suggest that going at her for dropping him off at a party, is somehow bad, somehow makes this her fault or something like that. Could be because he was present at One Meadows Avenue when the family went back there later in the morning. Karen went back with her own family. So he's an eyewitness to some of that. That could be why the defense wants him on, but I don't know if they know what he's going to say. The only thing that, we can know based on Carrie reporting is that exchange in the hospital. Aaron, Paul, kids, etc., being only on the Commonwealth's witness list means that there's nothing they have to say that is helpful to the defense. The defense doesn't, trust them to wing it, perhaps, to ask open-ended questions, exploratory, see what you get. Aaron did testify at the last trial, so they do have some information from her, but overall, is it generally helpful? I'm not sure. I don't really think that it necessarily is. It was mostly background information. So that's my best read on it. They think that there's possible, some reason why that statement from John O'Keefe at the hospital from John Sr. might have been helpful. They may know something else that he said if it's been, produced in discovery. They may know something else that he said that they think is potentially helpful. And the other witnesses, there isn't anything. So that's how the battle lines are drawn. AG 4981, Commonwealth says he died from hitting head on frozen ground after being struck. Bukaki says he hit booty first. Do you think defense will point that out? He didn't specifically say he hit booty first, just that if he was being dragged, it would be on both. And, his explanation of the grass stain is that this might be how he landed. Is it possible he landed head first and is still in motion and bounces and skids on it? I don't know. I have no idea. I have no idea what the theory of the mechanism is going to be this time. We got a 30-foot pirouette through the air last time after being hit by the arm, not on the center of mass. So I have no idea what we're going to get this time. Your explanation does seem to make more sense to me about if you got a grass stain, that might be how. Does that preclude you also hitting your head on the ground? It doesn't. It doesn't. I'll give you my example. I've told this before. Last time I really knocked myself silly. Haven't done it that many times. But oh man, I cracked my noggin so hard. I saw stars. I was at Crystal Mountain snowboarding. They hadn't gotten any, new snow for a while. So it was icy. It was the Cascade cement. It was compacted. It was icy. Not a very good condition. I'm coming down one of the main trails towards the chairlift. And I'm going to take my back edge turn, and I don't catch the edge. It scoots out. And just instantly my feet kick out, butt first, head slammed back into the ground. Oh, I saw stars, but I hit my butt first. So I could see that. I could see that happening. You hit butt first, and it's just because of your momentum. Your head continues down towards the ground. So I'm not sure that these things are mutually exclusive, but who knows? Who has any idea what their theory of the case, what their mechanism of the injury is going to be this time? It's probably not going to be the 30-foot pirouette, but we'll see. Zencat, off topic, but can we get a critter cam? I'd love to see your chickens. Oh man, it would, I don't even know how to begin setting that up. The critters are some distance from the house. What I will do at some point, I take pictures of them. Maybe I'll see if I can find one that I can share, something relatively quick and easy, rather than having a full like live critter cam. Maybe I can find
Here we go. I'll share this with you guys. Let's see. Can we see this here? This is out in the chickens' yard. So they're getting big now. They got their feathers on. They're outside. They live outside. Go out and around. There's a whole few of them. These are the little babies making all their little fun noises. So not a live chicken cam, but those are the babies. Those are the babies. So there you go. There you go. Not going to probably go to the trouble to figure out a live critter cam, but those are the chickies for you. Heather S. In my opinion, Commonwealth often sandbag defense with motions. Pre-trial, Hank Brennan said make a motion for everything, refused to discuss solutions, often dropped it after defense spent time responding and prepping for argument. Typical. For a difficult prosecutor, yeah, might be. Making you put everything in a motion is not that unusual for an asshole prosecutor. Not really that unusual. Oh, you think you got something? They're not going to give an inch. So you think you got something? Take it to the court. Make you litigate anything. Not make reasonable concessions about how the rules of evidence apply, what they're doing, what they're not doing. I mean, sometimes I had a case, the whole case went to trial because the prosecutor simply refused to look at the statute that defines, here is what the unit of prosecution for the crime is. The unit of prosecution for the crime tells you how many charges can you bring against somebody for, the conduct that is at issue. With an assault, for example, you don't get to charge everybody for every single punch that is thrown in a fist fight. Assault is considered a continuing course of conduct. So you don't get to file like 20 separate assault charges for one fight that took, 2 minutes because of the number of punches thrown. It's one count of assault. That's based on how the unit of prosecution is defined. So sometimes you end up going to trial because the prosecutor just won't see it reasonably. And you have to, like in my case, judge won't read the statute either. So we got to take this whole case to trial. Goes up on appeal. Yes, we win it on appeal because the freaking statute says so. It's obvious. But we had to go through a whole trial to get to that point because nobody wants to be reasonable and make reasonable concessions about what they can and ultimately can't do. So, some of that can be typical. There's obviously gamesmanship in the trial work and, draining the other side's resources. Not unheard of. Not unheard of. Now, are these asshole moves? Yeah, they are. They are. But are asshole prosecutors rare? No, they're not. It's not necessarily the way it should be, but I think I'd be lying if I said this was uncommon. You never see stuff like this. No, unfortunately, you see it all the time. Pablo with the super chat. Thank you for that, Pablo. Appreciate your support. Pablo, did you see the car Higgins moved at 137.15, 137.20 in the top left over the hood of the truck? So I did see it when we first watched through that video yesterday. I didn't see it initially. Folks had to point it out to me. I was staring at where I saw Higgins last go, which was kind of behind the corner of the Jeep. And then I don't see him again. So I'm like watching that space to see where does he reappear. I didn't even see the car in the background moving. So that was pointed out to me. Then we went back and took a look at it. I thought it looked like a, old school muscle car. It's just this shape that it looked like it had to me. But again, video is not necessarily very good evidence, guys. It's not necessarily very good evidence. Don't know how many inferences you can draw from it. So what was he moving? I don't know. Was it even him moving it? I don't know. I didn't see him go in and get in it. I didn't see him move at any point after he went behind that Jeep until he comes back into view from the other side of the camera. So we know he went somewhere. Seems logical he moved that car. Do I know it? No. I don't know. Video doesn't show it. And to the extent the video shows anything, the video is not necessarily all that clear. Leslie Howerton has joined us as a member. Thanks, Leslie. Appreciate your support. Welcome to the channel. Top trials. How much trouble would Brian Albert and Higgins get for him using his key card? Seems to me this is why they got rid of their phones. Possible interpretation. Now there is reconstruction, like we've been talking about, that law enforcement can do from the phone records, from the call detail records that they get from the phone company. But it may not be as precise as the kind of information that they can get from the phone itself, from location services, from GPS and so forth. GPS in general, if it's good, tends to be more precise. But it just depends. It depends on the density of the tower coverage and, the strength of the signals and so forth. If the phone is connecting with multiple towers at the same time, that can help you triangulate where the phone is. They use the advanced timing records for that. For those of you following Koberger, you know a little bit about the advanced timing records. That is a measurement of the length of time it takes for the signal to pass back and forth between the phone and the tower. So that can help you place how far the phone is from the tower. Then if you know which direction the tower is pointing, say the tower is pointing like this, it allows you to place the person, on this wedge. If you have more than one tower that you can get this information from, then you have now two distances, two lengths, and you can do the rest through trigonometry. So you can get some fairly detailed location information from call detail records if that type of evidence is available, but we don't know if it is. During the first trial, Tully, I think it was, testified. Was it Tully? About trying to do this type of location analysis from the call data records with Karen's phone, and he was specifically trying to track her phone after she left John O'Keefe's house, but before she got to Jen McCabe's. And they seem to be trying to create an inference that she had gone back to 34 Fairview before she went to Jen McCabe's house, but they couldn't prove that. It was never, never substantiated. They couldn't say, yes, we have evidence that puts you there. And some of that, I think, was because of the limitation of the cell information. You can't get that precise of information. So they weren't able to substantiate this idea or this theory. If that's the case, and Tully knows what he's doing and is doing it correctly, and the reality is all they're doing anyway is putting it in something like Trax or CellHawk. They don't need to analyze it themselves. They just need to have a mapping tool that they can use to plug the information into. If it's not good enough, then they may not be able to get that level of precision by looking at call detail records. So it's not the only way that feds can get location data. It's not getting rid of your phone if you're concerned about location data isn't a 100% guarantee. And I would expect that they would know that. So I don't know, but I understand. I understand this theory. Because you're going to get the phone records and the text records. Who were you talking to when? And a lot of that stuff, you're going to get that from the call records. So is there something else in the phone you don't want people to see? What might that be? Location data, health data, could be a lot of things. As far as trouble that they would get into, I don't know what the law is in Massachusetts, but it's probably a trespass, and it's probably a trespass into a protected area. I would imagine any normal person that is, not authorized, that is breaking and entering into a police department, you're entering without lawful authority to do that. It's probably a serious crime. I don't know for sure, but typically breaking into something like a police department is going to be a serious crime. Okay, no, he didn't break a window. He didn't bust down a door. That's not usually what the defining fact is. It's, do you have authority to go in, and did you do it anyway? If somebody is burglarizing your house, it's not less of a crime if you left the door unlocked. So I would expect that to be a pretty serious crime if that had happened. OCD Shaggy, off-topic hockey question. Any opinion on the rebrand from Utah Hockey Club to Utah Mammoth? I love the name and logo. Hashtag Tusks up. I don't follow hockey. Sorry. Very, very nominal follower of hockey. We do have a local hockey team, the Tri-City Americans, part of the Western Hockey League. It's one of the feeder leagues to the NHL. But I haven't followed hockey even locally since maybe, I don't know, 5th or 6th grade. I mean, it's been a long, long time. So I don't have any opinion. I don't. In general, mammoths sound cooler to me than hockey club. Like, what even is your mascot for hockey club? I don't know. But I say that as somebody from the team of the Tri-City American. I like mammoths. I think that's generally good. My completely uninformed knee-jerk opinion on this is I like it. I like mammoths. I like it. That's a good one. Charlotte ASMR, thank you for answer. BK, KR, BK, and RA have significantly hurt my trust in criminal justice system, but things like this, common as defense attorneys well aware. How do you reconcile lack of ethics versus standard, and what can regular people like us do to not end up like Karen Reed, etc.? Unfortunately, one of the best things that people can do to protect yourself from being in a situation like this is don't trust the police. Don't trust the police. Don't think that they're your friend. And it's sad to have to say that. You know, don't try to be helpful. Don't try to provide information. They're not your friend. They just aren't. Another thing you might do, you can advocate for changes to law. One of the biggest problems with the law that we have, in my opinion, in terms of trust between law enforcement and civilians and the ability to distort and manipulate that and create some very, very bad evidence, bad information, their ability to lie. Law enforcement can lie to people. How is that not just an invitation to distrust? If they can lie to you, then I'm going to expect you to lie to me. And unfortunately, you should. For your own protection, you should expect them to lie to you. It's very unfortunate. But the U.S. Supreme Court said so, 50 so years ago, maybe more. I don't remember what year Frazier v. Cupp was. But yeah, they're allowed to lie. States can change that by legislation. Some states have started to adopt laws that prohibit lying during interrogations. Very common with juveniles. There's I think, bill pending in Washington, bill that got introduced that would prohibit law enforcement from lying to juveniles during interviews. I would humbly suggest that could be broader. Juveniles are not the only people that are susceptible to false confessions when police lie to them. And that's because you trust the police. You trust the police. You're sitting there in an interview. You trust them. You don't believe they can lie to you. They may even lie to you about their ability to lie to you. I couldn't lie to you. That would be illegal. Didn't Jerry Holman say something like that in one of those interrogations of Richard Allen? I'm not allowed to lie to you. I'm telling you the full truth. They can lie to you about lying to you. So if you trust law enforcement and you think they can't lie to you and they tell you, we've got you on video, and you know in your mind you didn't do this, you have no memory of it, you know exactly where you were, you know exactly what you did, but you don't believe law enforcement can lie to you and they're telling you, we have you on video doing it. What happens? You might start to question your own reality and your own memory. Is it possible that I forgot? Is it possible that I was sleepwalking? Is it possible that I snapped? I had some kind of psychotic break? And then police will walk you into that. Well, is it possible? That's how the read technique is designed. It's literally part of the process. Try to walk you into what's possible and minimize it. Maybe you just lost your memory. Maybe what you did wasn't really that bad. So unfortunately, not trusting police is probably one of the most important steps that you may need to take for your own self-protection. How do you reconcile lack of ethics versus the standard? It's predictable. Just like it is in sports, you have rules in sports. In boxing, you're not allowed to hit below the belt. You're not allowed to rabbit punch, in the back of somebody's head. You're not allowed to slap. You've got to hit with the top of your glove. Not allowed to grab, not allowed to hold. But it's the most predictable thing in the world in watching boxing that one or more of these things is going to happen. It's predictable. And unfortunately, the legal system is the same. The rules are what they are, but it's very predictable that people are going to break the rules. People are going to play dirty. It's very predictable. So you just have to, foresee that. Try to have a plan to address it or to mitigate it. Make your record of what's happening and the fact that it, is against the rules. Call it out. It's really the best you can do unless you want to get in the mud and be a dirty fighter yourself. It's not really recommended. At the end of the day, you got to go home and look at yourself in the mirror and respect what it is that you do and what you contribute. And it's harder and harder to do that if you sacrifice your own integrity for the sake of getting a win or for the sake of getting back at the other guy who's not playing fair. It's harder to do that. So thank you for this question. I hate to, have to kind of be the cynic like that, but that is the bottom line. You can't trust the police. They're not your friend. They will lie to you. Act accordingly. Nasir Puto, how did the medical expert for the prosecution do in the last trial? They seem scared to present the expert now or wait till the end. What do you think the strategy? What do you think is the strategy now in the second trial? So much of what we're seeing now seems to be it's Lally's case. It's just edited a little bit. It's just edited. They're not bringing out every single person who is on scene. They're not bringing out every single person who is present in 34 Fairview. Hank is being more selective with who he is choosing to sort of represent that. There are upsides and downsides to that. For example, okay, you didn't need to call every single first responder to the scene, but if you don't call Matthew Kelly and the defense calls him to testify, yeah, I was there with Flamati and Nuttall. I was down there while we were doing the CPR with John. I was down there by the feet. I worked my way in. And no, I never heard Karen Reed say, I hit him, I hit him, I hit him, which is what he testified to at the first trial. He never heard it. So that's going to conflict with Timothy Nuttall's account of how this happened. But it also now makes the Commonwealth look like you're cherry picking just what you want to present. If the defense has to elicit that, that's a trade-off. So that can hurt the Commonwealth's credibility. But structurally, I just the longer this goes on, the more it looks like Lally 2.0. This is an I hit him case. It is not the facts and science and data that he told us it was going to be an opening. Because that's not what we've heard. We haven't heard any of that. We've heard I hit him from a few different sources. So tried to convince us, gave us that head fake that it was going to be a different case, but it's not. Structurally, following a lot of Lally's case as well. Lally left all the technical stuff to the very end. It became a just repeated refrain. Day 20. Are we going to hear proof that John O'Keefe was hit by a car yet? No. And we're having that same refrain now. Well into the Commonwealth's case, we are supposed to be at the tail end of it. Hank had estimated 3 to 4 weeks to put on his case. We are in week 4. We should be at the tail end. Still haven't heard a speck of this fact, science, and data that's supposed to show that Karen Reed hit John O'Keefe with a car. Haven't heard anything about John, and there's a reason for that, because it's a weak point. There's a reason why the defense is highlighting John's injuries and the Commonwealth is not. Because if the Commonwealth really thought, like Sergeant Buchanan testified, oh, his arm made it clear that we're dealing with a vehicle collision, not a thrown glass. Arm made that clear, we would have heard medical evidence of that. We would have heard it already. If it's strong evidence, we would have heard it already, but it's not. So to get to your question, as far as the medical expert, in the last trial, the medical expert was the medical examiner, Dr. Irini Scordi-Bello. And she is not a strong witness for the Commonwealth because she concluded that the manner of death was undetermined. She could not determine it was a homicide. We heard testimony that when she makes that determination, she is working in concert with the investigators. She is receiving information from them. She is learning what their theory of the case is. And that all goes into understanding the facts and circumstances surrounding the death so that she can make a determination about how it happened. And so, in spite of that, in spite of being informed about the Commonwealth's theory, she wasn't able to medically confirm it. Yes, this is a car accident. She wasn't able to do that. And she testified specifically, these are not traditional injuries that you see from a pedestrian vehicle collision. Many of these injuries, however, could be caused by a fist fight. So she wasn't very helpful. That's the reason why, I presume the Commonwealth has a new medical expert. They have their neuroscientist who's going to testify at least about the injury to his head, brain injury. Is he going to have other stuff to say? I don't know. He's not a pathologist, so don't know that he's going to have the expertise to opine about things like the wounds to the arm, mechanism of injury, and so forth, like what looks like a car accident. I don't know. You're not a car accident guy. You're a brain injury guy. I'm sure you probably see brain injuries in car accidents. But I'm sure you also see brain injuries in a lot of other contexts. So they seem to be needing to bolster the medical evidence. Scordi-Bello was not a strong witness for the Commonwealth at all. Of course, we know that the defense has multiple medical experts. They're going to be saying this is not a car accident. Those are dog bites, etc. Apparently some other things they're going to say about hypothermia and whatnot. So, I think their strategy is to try to bolster the case, try to get some more medical evidence to either replace or at least supplement the medical examiner. It's another one. If they don't call her, gosh, that doesn't look good. It really doesn't look good to not call the person who did the autopsy, because the defense is going to call her. How do you not? How do you not call her? She is literally the one who examined his body to make a determination about the cause and manner of death. And the Commonwealth doesn't call her. Oh, that would be a very bad look. I mean, talk about looking like you're trying to keep information from the jury. Hard for me to believe they would do that, but they might. They might. It's all trade-offs. So their plan seems to be to supplement, bolster, replace potentially that testimony. And then structurally, it's the same as Lally. We're just leaving it to the end. We're kicking the can down the road as long as possible because we're hoping I hit him sticks and gets in people's mind and persuades them to then apply your cognitive bias and interpret the rest of the evidence that's presented with you in the way that is confirming the I hit him theory. So you could interpret Squirty Bello as reasonable doubt, not traditional vehicle pedestrian collision injuries. Could be caused by a fist fight. But you could also interpret it supporting I hit him. She didn't say it absolutely couldn't be from a car accident. Pretty much went with the anything is possible kind of approach to evidence. So that's what I see. I see it being kicked down the road. I have not seen primacy and recency make a significant appearance in the Commonwealth's case. It doesn't seem to be a huge factor in their decision making. They've just made some very bizarre decisions about how they lead off and how they conclude. Going to that, like, just the one that stands out in my mind is you played all of Karen Reed's voicemails to John. We have all of these, screaming, calling him names, unpleasant stuff. But then you finish with that one at the scene, and then we go to lunch. So, like, of all the voicemails that you just played, that's the one that's most recent. That's the one that's going to kind of stick in your mind. That's the one that you're going to focus on. Just very strange decision making from that standpoint. So, not really sure. Not really sure that that's driving it. It's stronger this time, so they're going to leave it to the very end. I don't know about that. I really don't. If the text stream data, for example, were so strong, we would have heard about that, and we wouldn't just have all of these contradictory and contradicted accounts of I hit him. That's how I see it. It looks like Christina Rex is reporting 2 sources confirmed to WBZ that Karen Reed is sick, which is the unavoidable circumstance that canceled court today. We have not received a scheduling update for the rest of the week. So 2 sources. It's Karen. She's sick. That is kind of a classic unavoidable circumstance that does come up in trial sometimes. Makes sense to me as an explanation. So I accept it. It's plausible. That is probably why we are not having court today. And they'll probably just be taking it kind of moment by moment and see what develops in the coming days. Well, guys, hey, almost 4 hours without even having court to just chit chat about what's going on and watch that new evidence, see what we can see in it. What can we make out of it? What can this tell us about how they may be approaching calling Higgins as a witness? What might they ask him about? How does it conflict with his prior testimony? It's compelling stuff. It's compelling stuff. This video does not seem to correspond with his previous testimony. So what does that mean? I think they're going to call him, guys. I think they're going to call him. We'll see what happens. But so in the meantime, hey, I'm going to plan to be here at the same bat time tomorrow. Assume that we'll be able to go forward with court and we will just play it by ear. I guess if we hear anything in the meantime, they may know before the end of the day. If they're expecting her to recover, they may know by the end of the day. If by the end of the day she's still in bad shape, they may already have plans to not have court again tomorrow. So barring new information, I'm going to plan to be here tomorrow and assume that trial will get back on track. And then we'll see where we go next. Kind of the $1 million question at this point. Done with 3 days with Sergeant Buchanan. That's the longest cross of both trials so far. 2 full days of cross-examination. That's the longest one from both trials so far. So he really got the marathon
the marathon session. Real test of his endurance there. Sure did seem to get a lot more agreeable as time went on. But so where do they go now? I mean, remains to be seen. Certainly have our expectations of what's still to come, but who exactly is it? We don't know. Hey, why don't we go ahead and one more thing before we rack up, before we get the stream all tied up. We do have a witness list compilation. This is kind of hard to see at this size. Let me see if I can actually get it bigger. There we go. That's a lot bigger. That's a lot more visible. And so this is a compilation of who is on whose witness list and then who is on both witness lists. So we can kind of go through and see where are we at, who's been called, who hasn't been called. So on both witness lists, almost none of these people so far. Okay, Yuri Buchanan got called. Paul Gallagher got called. Heather Maxson got called. Jen McCabe got called. Carrie Roberts got called. 5 out of 31 people in common that the Commonwealth has called so far. Are they going to call all these people? It seems very doubtful, doesn't it? Seems very doubtful. Only on the Commonwealth's witness list. Okay, we got Jason Becker. We got Michael Camerano. We got Gary Fowler. We got Anthony Flamati. We got Robert Gilman. We got Nicholas Guarino. We got Jessica Hyde. We got Hannah Knowles. We got Sarah Levinson. We got Katie McLaughlin. Okay, that's 10 so far. We did get Bridget Meehan. That's 11. Timothy Nuttall, Kevin O'Hara, Margaret O'Keefe, Charles Ray. We're at 15 now. Ian Whiffen, Daniel Whitley. We haven't heard from Dr. Wolf yet, have we? No. So we're at 17 out of the 57 on their list. 57 on their list. They've called 17 and 5 of the 31. So there's a lot of directions, a lot of places that they could go. But I know I'm getting the sense that they are just editing substantially. Turtle Boy, for example, on the list. Are they going to call Turtle Boy? No, I don't think they're going to call Turtle Boy. Turtle Boy has already said he would plead the fifth if he's called. So you don't have a good faith basis to call him. But we do have some other expectations. James Crosby. Now, they've tried to pitch James Crosby as only being, as being direct, not being Sir rebuttal to Garrett Wing or, any of the other witnesses. But he might be just called in rebuttal, wait for them to put on the defense case. Talked before about Maureen Hartnett. She seems important to me because she is from the lab. Where is she? Oh, she's on both of the lists. She's important because she's from the lab and she's the one who went to, as far as I remember, she's the one that went to the Canton Police Department, recovered, the evidence from there, took it into custody, removed the taillight, took that over to the lab, got the bumper sprinkles, etc. And then did did some of the testing with it. So she seems pretty important. Probably still to come, but Proctor? A lot of rumors that they're not going to call Proctor. Don't know. Oh, Ryan Nagel, I guess, got called too. Did I forget him? I might have forgotten him. Irini Scorti-Bello, a lot of rumors. She may not get called. They may not call her. Rest of the O'Keefes, rest of the first responders, Stephen Mullaney. Are they going to call Stephen Mullaney? Because he didn't hear I hit him, I hit him, I hit him. So are you going to call him? Stephen Seraph? He didn't hear I hit him, I hit him, I hit him. Are you going to call him? Yeah, I don't know about that. I don't know about that. So this might speak to maybe some of that gamesmanship that you folks had asked about earlier in the chat. You know, filing the motions to kind of throw the defense off and get them to devote their resources to stuff. It might be the same reason why you would pad your witness list, put a bunch of people on there that you have no intention of calling, but it forces the defense to have to prepare as though you're going to. Could be a little bit of that at play. It's not uncommon also to just be over-inclusive in your witness list. You want to hold out the possibility of being able to call these people. If there's any way they might contribute to the case, you don't want to take it off the table. So there could be a little bit of that as well. Katie Kane, I must have missed it. What are the bumper sprinkles? Love you, by the way. Let me see if I can find real quick. Maybe in Sleuthy's spreadsheet. Maybe in Sleuthy Goosey's spreadsheet, which all of you should have and refer to all the time because it is so fantastic. Yeah, it's there are photographs of it from the first trial, but I don't know what they were called, if we're going to really be able to clearly see them. Let me see, maybe the SUV. Lexus. See if I can find a photo for you that shows the bumper sprinkles. So they recovered glass from the rear bumper of Karen Reed's SUV. But the lab went and did testing on it to see, does this match the glass, the cocktail glass that was recovered from 34 Fairview? And it does not. The glass all matches itself. It matches the other glass, but it doesn't match the cocktail glass. So the $1 million question then is, so where did this glass come from? First, we are expected to believe, once again, it, like the hair that we heard about in opening was found, attached to the Lexus, somehow survived, being driven all around Canton, parked in a snowstorm, towed, high winds, etc. But the hair remained stuck to it, so they found it days later in the Canton Sallyport. Similar with the bumper sprinkles, that the glass just here's a decent picture. Let me share this one. See if I can get this up. The glass just somehow remained on her bumper that whole time. And let's see. And then they were able to go and recover it and do the testing with it. So this you can kind of see, look, there on the bumper. There's no snow left, right? This is days later. This, if I remember right, was February 3rd or February 4th when the crime lab folks went and did their work on the SUV. So you can kind of see, once again, not a great photo, but this little residual stuff there on the bumper. Those are the bumper sprinkles. So that's what those are about. It doesn't match anything. If the theory is supposed to be it's from John's glass, it's from the glass that he was holding or he threw or whatever. So there's glass on the bumper. Okay, but it doesn't match the glass. They went through and did like a molecular type of comparison and it doesn't match the glass. So where exactly did this come from? Where exactly did it come from? What's the theory then from the Commonwealth for how that glass ended up? How did that glass end up on the oh, here's another photo that's pretty good. Let's go ahead and bring that one up. Big close up of the there's a lot of discoloration, it looks like, so kind of a little bit hard to tell what's what. How much of this is salt residue? People have mentioned the taillight pieces. Would there be salt residue on that? Maybe. Maybe. We didn't seem to see any, but certainly, you know, a lot of residue on her bumper. But this is where the glass is found. The glass, little glass pieces. They don't match anything. And we never got a real good explanation for, so where exactly did that glass come from anyway? Oh, Karen Reed, defense, probably has a theory about where it came from. If we think that the Commonwealth is over here, some of the investigators, like Proctor, just trying to, you know, plant a little taillight here and there, boost the case against Karen Reed, might they also sprinkle a little glass on the bumper? Really sell it, knowing that they found that cocktail glass at the scene, one of the first pieces of evidence they had to work with, and they really tried to work with that initially, didn't they? Sold it to the medical examiner. Might be that. So maybe you'd sprinkle a little bit of glass on the bumper to try to substantiate this theory, but unfortunately, it doesn't match. So creates a little bit of a problem with the evidence that you have. How do you explain? Where did this glass come from? Where exactly did this glass come from? That's the story of the bumper sprinkles. All right, guys. Well, I'm going to wrap it up. Appreciate so many of you joining me and sticking with me for this long, even though we didn't have any court. No court to watch. Just kind of wait for some updates. Take a look at that, a little second look at that new video that we got to see yesterday. Whatever else it shows or doesn't show, does look a little sus, doesn't it? Getting in and out of all these vehicles. Looks like a duffel bag. So hard to say. So hard to know what we're seeing on this camera and what we're not seeing. Video evidence, we'd love to think it's super good and super reliable, but often our eyes deceive us. Often our eyes deceive us, and it can just be a way to project what we expect to see onto ambiguities in what's visually present. Very hard to know what to make of this. But what I do know, it doesn't fit Brian Higgins's time frame from the first trial. It doesn't really seem to fit his account of what he was doing either. So that doesn't look very good, guys. Doesn't look very good. And yeah, should have been turned over. Yeah, this is Brady. As soon as he testified at the first trial, there at 12:30, moving the cars. Yeah, this is impeachment evidence. It should have been turned over. And of course it wasn't. But no harm, no foul in this courtroom, because here we are getting a second trial. So now they get to cross-examine Brian Higgins, but the Commonwealth may just not call him. So if the defense is in the position of calling them themselves and that's their remedy, well, they better be able to treat him like it's a cross-examination, even if he's their witness. That's how I see it. Otherwise, that's not a complete and effective remedy. So with that, guys, I'll plan to be here tomorrow. If I hear something different, I'll put it out on the community post if we're not going to have court, if we get notified of that. But it's probably a monitor, wait and see type of situation. Hopefully everything just needs, she just needs a day of rest. Everything will be better tomorrow. And we'll get back in court, see where the Commonwealth goes from here. Get ever so closer to wrapping up their case, because I'm excited for what the defense has. I really am excited for what the defense has. They have really boosted their roster. A lot of experts. I'm very eager to see what they've been able to do in the intervening year.
with this new evidence, these new resources, and so forth. So getting closer and closer every day, but not today. Not making any progress today. Thank you again, everybody. Appreciate you joining us. Final word. Yes, court was canceled today. Unforeseeable circumstances was the official notice, but there's been some unofficial reporting that it's due to illness. That does happen. Not unheard of. People do get sick, and especially if it is somebody who has a right to be present, like Karen Reed, or somebody whose presence is fairly fundamental, like, for example, one of the lawyers. You just don't have a lot of choice. Nobody likes to get sick. There's never a good time to get sick, but in the middle of trial is kind of classic when you will get sick, especially if it's a long trial. It happens. And if it's a situation where you can't get by without the person, then you just have to put it on hold. And not the end of the world, but we'll be back tomorrow. Thanks again, everybody, for joining. Thanks for your comments and your thoughts, your questions, exploring, sharing your perspectives on this. It's been a lot of new stuff to take in. A lot of new questions come up. I understand people's reactions to the video. My initial reaction, boy, that sure doesn't look like Brian Albert, or sure doesn't look like Brian Higgins. But the reality is video isn't particularly good evidence. And remember that too, when we're looking at the taillight video and stuff. Maybe there's a way for the defense to use that. I don't know. We'll see. So with that, guys, be back bright and early tomorrow. Thank you, mods. Thank you, chatters. Thank you, everybody. Appreciate you being here. And we'll check in and see what tomorrow morning brings. Take care, everybody. Enjoy your day off, and we'll see you then.